Can it be tomorrow, your lordship? Listing of a criminal appeal, your lordship. Tomorrow is possible. Otherwise on Monday, criminal appeal, your lordship. Monday, otherwise.
It's for motion.
It's for orders, your lordship. We have taken steps against the respondent number 2 informant for orders.
Monday, Tuesday, Wednesday. At best 10th, you say.
On 10th,
Because, yes,
Wednesday.
lots of mentioned
Wednesday.
matters have been.
Okay,
fixed,
sir.
yeah.
Okay.
May I please, your lordship? My lord, I beg for mention for withdrawal, my lord. My lord, to take, maybe taken up tomorrow, my lord.
Okay.
Highly obliged, your lordship.
No, please, Your Worship. I pay for listing a criminal petition for orders. My lord, give any date. It was listed in last week, but it becomes late over my lord.
10th.
Obligement.
May I plead to lordship? Lordship, I beg to mention for listing on criminal appeal, lordship.
Or orders call or both.
Admission, lordship.
Admission.
Yes.
9.
Nine.
9 should come.
Another IA, lordship, IA criminal.
Maybe on 11.
Lordship.
May I please, Your Lordship?
May I please, lordship, for
mentioning for listing of criminal petition by any date of next week. Also.
Yeah. 11th of September.
May I please, Your Lordship, for listing of a criminal petition, Your Lordship. It was last listed on 9/5, Your Lordship. Any date in next week, Your Lordship. For admission, Your Lordship.
Okay. No prior date, maybe on 15th.
15th.
Yes, 15th.
And Your Lordship, one more, a criminal revision, Your Lordship. Similar matter, Your Lordship, for admission, Your Lordship. Criminal revision,
Maybe on 15th.
15th, Your Lordship. Obliged.
please, similarly for criminal petition on for motion, any date next week, lordship.
Maybe on 15th.
I look.
Please, your lordship. Also, I beg to mention for listing of an IM for orders. Any date next week.
11th. 11th of September.
May I please, the lordship. Lordship, I am praying for listing a criminal petitions, lordship. Any date on next week, lordship. That's because lordship in the last occasion in the about 1 year back, lordship, a report has been called. So already report has been received. I have checked this in this section. So any date, lordship, on the next week. 10.
And for lots of, no, not 10th.
Okay,
We cannot.
11, 12, any date. Highly obliged.
May I please, your lordship? I beg to mention for listing, lordship. Because the last posted 22/8/2024, lordship. Kindly consider urgent matter, lordship.
We cannot consider because we don't have any space to. 15th or 16th. At best on 16th. 16/1/6.
May it please, your lordship? I beg to mention item number 28, your lordship. The arguing counsel is out of station for some medical emergency.
28.
28, yes, sir. Lordship, kindly matter may be taken after 1 week.
Request and box. Please let me try about. I don't need it.
May I please, your lordship? For listing criminal petition, lordship, for admission, lordship. In this case, lordship, the petitioner and the accused, both are husband and wife, lordship, jointly filed this petition, lordship.
Wrongly?
Jointly filed this petition.
Jointly.
With husband and wife.
Joint or separately, that doesn't matter, but the question is that.
Criminal
Maybe
for
on
admission, had
16th, 1/6.
1/6.
Prior to that, we don't have. I do, maybe. And we don't have to do such a thing. He was going to get some. You understand? They found the We took 59 minutes. Thank you. We talked it. Who will wanna go? I don't. Apa correct?
May I please, Your Lordship, Lordship for listing one criminal revision petition, any date on next week on hearing.
Date on next week, and based on 16, one since.
Lordship,
16th of
actually-
September.
Actually, this the respondent, I responded number 2 and the petition, thus honorable court has stated the allowance of maintenance. So that's why I am suffering.
21, 16.
Yes.
Delay no more.
Rashid, I'd like to mention the criminal petition for listing admission.
16.
May I please, Your Lordship, Lordship, I am paying for listing of 2 criminal revision petition. Since 2024, it has not been listed.
It is good.
Can it be on Monday?
18th of September.
My lord, the next date in the lower, in the court below is fixed and 16.
We don't have any option. Maybe.
Well-
You may approach registry in that case. You may approach registry in, if it can be accommodated in any other court, it can be, but we don't have any. space.
It's fine, my lord, maybe it on
18.
18.
Only.
May I please, Lordship, I beg to mention item number 24, Lordship. Lordship, objection of basic, Lordship, kindly pick some other day, Lordship. Short time
24.
may be given, Lordship.
But we have received this scan copy of already.
Lordship, objection not received. Of function of other side,
You have not filed objection.
Lordship.
Last occasion also, I think,
Maybe
you
Lordship.
wait for some time for filing objection. Then what had happened? At a request, with the consent of the other side, the learned council, in on behalf of Mr. S. C. Kyle, standing council NCB, with permission stating that some time is required for filing the objection. Fair adopt. How many weeks you need?
उनका भी तो फॉलो है 9th of August 9th of September Lordship.
9th of September. Ima, you did. You. 11th of September.
Oh, bless Lordship.
May it please, Your Lordship. Lordship, I beg to mention item number 7, my lord, on behalf of Mr. A. Deka, my lord. In this case, we will file some additional affidavit, my lord.
You have already filed.
No, we'll
You are
file,
going
my
to
lord.
file. Item number 7,
7,
A Deca.
A. Deka.
So that will be fixed on behalf of A Deca. After 2 weeks will do.
Next week, if possible.
The date we cannot fix it. After 1 week it can. After 1. As on a date. we fix.
May it please your lordship, and commercial quantity and the best case.
The case of commercial quantity.
Yes, charge sheeted bid. Arrested on
Recording.
23/11/2023, lordship.
Is well.
Arrested on 23/12/2023, 1 year, 8 months, 11 days, lordship. That's something.
We are calling for the scan copy of the TCR. In the meantime, you can file your objection. You can
Lordship.
scan copy of the TCR. we call. And the respondent NCP may file the written objection if any, till within the on or before the next day. Place the matter on. Sixteenth of September will.
Lordship 22 September.
22nd of September. Registry will do the report in calling.
Bless.
Oh, bless Lordship.
May it please, Your Lordship.
Let's say here challenge is to a charge sheet, my lord. The lordship will have a look at page 25, my lord.
Yeah, then.
Page 25, my lord.
Yes.
The lordship will see, my lord, Hibzur Rahman, my lord. He is before your lordship, my lord. Now lordship will turn to page, my lord, 28, my lord. 28, my lord, serial number 16, my lord, brief facts of the case, my lord. May I read, my lord? The prosecution history of the case is that on 10/8/23, complainant so and so lodged an FIR and stated that on 9/8/23 at about 5:30 p.m., information received from a secret source that a group of 3 persons involved in ATM fraud and cheating were coming from Nagaon side to Guwahati side in a blue color Swift car bearing number so and so. Regarding the GD entry has been done by Nelly OP GD number so and informed to the OC Jagirod and superior officer. During Naka checking at about 7:30 p.m., the above mentioned car came from Nagaon side, but when tried to intercept, they increased the speed of the car and attempted to hit on duty police officer, but couldn't succeed and hit the barricade and rushed towards the Jagirod side. Accordingly, informed OC Jagirod and IC Nelly, along with so and so, my lord, followed the car in the government vehicle bearing number so and so, driven by so and so. Near Kumarbari Bridge, the above mentioned car bearing registration number. When the people in the saw the police chasing the driver, suddenly applied brake, and homeguard Shahidul Islam couldn't control and hit the car from back, due to which both the vehicle got damaged and 3 persons sitting in the car, namely Hanifur Rahman, Dewan Samsuddin, and number 3 Malar Saidul Islam, got injured, and 3 numbers of police personnel, namely so and so, my lord, got injured and admitted to the hospital immediately. Accordingly, accidental vehicle has been seized, and after search, found 37 numbers of ATM card, 1 swipe machine, 4 numbers of mobile phone, 3 numbers of purse, 4 numbers of caps, and 1 sunglass so and so wrapped in a plastic carry bag, duly seized and brought to the Nelly OP. Hence, the case has been registered and investigation is on. Well, next page, my lord. After investigation, a prima facie case under section so and so, my lord, against the accused person, namely Hanifur Rahman, Dewan Shahidul, and below your lordship will see, my lord, and Hifzur Rahman, my lord. Further, during investigation, no sufficient evidence have been found against other 2 persons, my lord. There are no sufficient evidence has been found. Now your lordship will have a look, my lord, at page 36, my lord. This petitioner approached this court, my lord, for bail, my lord, and he had obtained bail, my lord. Page 36, it starts, my lord. The relevant part, my lord, your lordship will find at page 38, my lord. But on the other hand, learned additional public prosecutor had produced the case diary of Jagirod PS case number 283 so and so and submitted. Though there are incriminating material against the other accused person, it appears from the case diary that the present petitioner is the owner of the vehicle which was seized in connection with this case, and he allowed his brother, who is the main accused in this case, to use the said vehicle. The complicity, my lord, in the case, my lord, I am the owner of the vehicle. And accordingly, my lord, Jimma was also granted, my lord, that your lordship will find at page 32, my lord. By this court, my lord, order dated 19/10/23, my lord, Jimma of the car has been given, my lord. No allegation as such against me, my lord.
Yes.
Yes, madam. Regarding the page 38, madam, it is regarding the bail, madam. So bail, the observation is very tentative, madam, not subject to, madam, because he was allowed to appear on that stage, madam. And now the search sheet has been laid out after his bail order, madam. He is on bail, madam. And the search sheet reveals, madam, there is sufficient materials against him, madam, in the.
No, that statement is not there, to be fair.
No, I have seen, madam. Motion may kindly come to search sheet.
At 28.
Yes, my lord.
29. 20 to 29.
Lordship,
29.
During page 29, my lord. During investigation, a prima facie case under such and such have been found well established against the accused persons, namely Hanifur, Dewan, Saidul, and Hifzur Rahman. This is the case now. That is why my charge sheet has been laid down, my lord. So now, my lord, he is on bail, my lord. No prejudice is caused to him. Let him face the trial, my lord. No. If he is, and charges are perhaps not framed, my lord. I don't know, my lord, about that, my lord. It's a very preliminary stage, man. And his vehicle has been used for committing that crime.
You are also representing Biman Kaur.
My lord, summon has been issued, my lord, that your lordship will find at page 30, my lord. Scan copy of the case diary may be.
Scan copy, my lord.
Number is at
No,
page 30.
I'm not on that.
My lord.
Oh, you have already issued. No, someone is issued. No,
Yes,
I'm not on
Summon,
there.
yeah.
I'm asking, Goswami, you are going to represent the number 2 also, but
Lordship,
by name it is there.
let notice may go to him after that.
Because by name he is
Yes,
there.
fine. State of person.
I'm the by person of by.
No problem. I go.
By Mr. Puja Dutta of the competition. And also had Mr. MP Goswami appearing on behalf of the respondent. This is an application, so and so. For watching of the charge sheet. Issue notice to the respondents. Registered people as usual for formal notices required to be served. On the state respond number 1. Copy of the petition may be served during the course. Also call for the scan copy to be seen. Your next date is fixed on when?
My lord, it is in the after puja vacation, my lord.
After Puja.
After puja, October. May.
We'll try to accommodate you before Puja.
Yes, my lord.
Let it be on 22nd of December.
My lord, can it be on 24, my lord? A little bit.
24.
24, my lord.
24th.
20.
You take steps for this.
My lord, I am obliged, my lord.
May I have a lordship?
In last occasion, Mr. Goswami was there.
Yes, I am there, my lord.
So
Well,
you're
if
supposed
a-
to file some.
My lord, I want to show, my lord, another decision, my lord, that's what I'm, my lord. On the other day, my lord, I have placed the materials.
Yes.
Now, my lord, go. Go. Well, this is a decision of 2019. निकाल के नहीं रखते मुक गया कौन तो है तीनों भाई का डिटेल्स तो नहीं है तीनों भाई कौन है दीजिए तब तो दीजिए तैयार दीजिए हाँ But I'm taking my lord to 42 paragraph. My lord, I'll not read the other thing.
Para number 242. Para.
My lord, para 20 also. Para 20, your lordship will, I'll just show one line, my lord, there.
Para 20 and.
20, my lord, at page 16.
Then other para.
My lord, other paragraphs are 29, 35, 36, 38.
Okay.
And 42, my lord. My lord, I'll show from paragraph 20 and 42, my lord. Rest, my lord, I'm not reading. So in para 29, the earlier case of 1979 that has been discussed. Thereafter, my lord, Vinay Tyagi, 2013 has been discussed. With the introduction of section 173(8) CRPC, my lord got it, my lord.
20.
Yeah, 20. I just read two lines. my lord.
Yes, it.
The police department has been armed with the power to further investigate an offence after a police report has been forwarded to the magistrate. Well, that proposition, my lord, I am not denying. Quite obviously, this power continues until the trial can be set to commence in a criminal case. Well, I'm just emphasizing on this fact. Well, in this particular case, in our case, my lord, the trial has already commenced. I have shown from the my lord, order sheet of the my lord, and Chief Judicial Magistrate. Now, my lord, you'll kindly see para 29. I am not reading. Para 29, the earlier case of 1979, which I have already cited, my lord, that has been discussed. Then, my lord, other cases are, different cases are, my lord, all the cases has been discussed from there, my lord, and 42, if your lordship kindly come to. 42. May I read? There is no good reason given by the court in this decision as to why magistrate's power to order further investigation would suddenly cease upon process being issued and an accused appearing before the magistrate. While concomitantly, the power of police to further investigate the offence continues right till the stage of trial commences. This is important. Such a view would not accord with an earlier judgment of this court in so and so, having clearly held that the criminal trial does not begin after cognizance is taken, but only after charge is framed. That fact has been cleared, my lord. Well, in our case, the charge has been framed. What is not given any importance at all in the recent judgments of this court in Article 21 of the Constitution of India, and the fact that article demands no less than a fair and just investigation. To say that a fair and just investigation would lead to conclusion that the police retain the power subject, of course, to the magistrate's note. But this portion is important. Note under section 173(8) to further investigate an offence till charges are framed. But that is supervisory jurisdiction of the High Court. Magistrate suddenly seized midway through the pre-trial proceeding would amount to a travesty of justice, as certain cases may cry out for further investigation so that an innocent person is not wrongly arraigned as an accused or that prima facie guilty person is not left out. There is no warrant for such a narrow and restrictive view of the powers of the magistrate, particularly when such powers are traceable to section 156(3), read with 156(1) and 2(x), and section 173(8) CRPC, as has been noticed here in above, and would be available at all stage of the progress of criminal case before the trial actually commences. It would also be in the interest of justice that this power be exercised suo motu by the magistrate himself, depending on the facts of each case. Whether further investigation should or should not be ordered is within the discretion of the learned magistrate, who will exercise that discretion on the facts of each case in accordance with law. Yeah, we clear the. So, my lord, my humble submission, two aspects are basically, my lord, I have made one submission that, my lord, the charge sheets, though I have not read the entire, both the charge sheets are, my lord, exactly same. No further material has been, my lord, brought out. My lord, your lordship will kindly see the further investigation is for the purpose of, my lord, bringing further materials, so that, my lord, there will be a fair trial, either for the accused or for the prosecution, whoever may be the. Here, that is not the case, my lord, nothing is, my lord. I have read the FIR, my lord, so far against me, my lord, the offence, my lord, other offences has not been made out, my lord. Only section 120B is there, just why, my lord, I have input. Thirdly, my lord, 173(8), my lord, I have shown, my lord, that power is there of the police to further investigate. My lord, but the judicial decision says that, my lord, the power has to be exercised, taking permission from the court. So, my lord, they have made a prayer in the charge sheet, my lord, I have said. But, my lord, no order was passed to that effect. And, my lord, in the meantime, so far the Partha Bhardwaj is concerned, the trial is also commenced. Charge has been framed, trial has been commenced. So, in view of all the facts and circumstances, my lord, at this stage, my lord, my query is at least my lord will issue a notice. Let the records be called for. And, my lord, your lordship will examine the matter, my lord. And, my lord, the next date for appearance is 26th of September. And, my lord, So far, the police is filing another charge sheet against some of the accused persons, my lord, for that. So order sheet, my lord. I'll just,
No, along with you, two others are
my
there.
lord, we are two, my lord.
You are two.
We are two, my lord. So far, the other party, my lord, he has not received the summons as per the orders of the court, my lord. Further summons has been issued. So far, my lord, I am concerned, my lord, I came to know, though no summons has been issued. And my lord, I have already appeared and filed an application that kindly give me some time, I'll appear. So, my lord, I am not going to defy, I'll definitely appear. But, my lord, subject to your lordship's, my lord, consideration, my lord, this issue is there, my lord. Let your lordship decide these issues, my lord. Or if your lordship feels that no, in the meantime, the trial, the proceeding should go, my lord. My lord, it will complicate the matter. That is the only, my lord, my.
But the proceeding of trial most probably will not be.
My lord, so far, my lord, I am
because
concerned. My lord, so far, I am concerned. I am not saying.
You are concerned and that but apart two, you along with one the subsequently charge sheeted. So one is yet to be, someone is yet to be received by the other one.
Yes.
So in that case, in that context only, I am saying that trial may not.
So it will not immediately may not proceed.
Immediately may
Because,
not
my lord,
proceed.
it will not immediately proceed also. My lord, then your lordship can, my lord, I am making a submission, my lord, that your lordship, so far my appearance and other things are concerned. Let me appear. There is no difficulty. Let the copy be served and other things, my lord. All these materials I can place before this honorable court. But, my lord, so far till the stage of, my lord, framing charges. Let the trial court, my lord, so that the proceeding will also go for, my lord. Because it will not complete within a period of, I don't think, my lord, within a period of 6 months it will be completed. I'll just show that. Order sheet is on. My lord, in the order sheet, your lordship will find original order sheet. हमको कहाँ दिया हुआ है? The last order, my lord, that is not probably annexed, my lord. I'll give to my lord. $19,700 का. वो चार्जशीट जो फाइल करने के बाद बोल रहा था उनको. 19,700 का लास्ट ऑर्डर कहाँ है? 19,700 का ऑर्डर. तुमको बड़ा दिक्कत कर रहा है. डोंट बी जो आफ्टर 6/6. Well, the last order is of 24/7 at page 340, my lord. तुमको जो बात बोल रहा है रेडी करते रहता है.
You have annexed the order, last order.
Huh?
You have annexed the last order. You have annexed the last order.
Well, 24/7 I have annexed, my lord.
24, page number 300.
But there is another order. और 24/7 यही ठीक है. तो पहले जो उन लोग को बोला था कि उनको चार्जशीट फाइल करेगा. In this order only, my lord, so far the production of the accused Partha Bharadwaj and for appearance of accused so and so and Kuruppan Nagappa. That is there. But there is earlier an order where, my lord, police is seeking permission to file a charge sheet against other persons who are absconded. So, my lord, anyway, my lord, my submission is that, my lord, if your lordship can protect, let the trial court proceed up to the stage of, my lord, framing charges. And in the meantime, probably, my lord, the matter can be heard and finally disposed of. So, my lord, my purpose is also served, my lord, and your lordship is not staying the further proceedings. And in the meantime, my lord, let my friend, my lord, produce or records may be, scanned copy of records may be called for. A scanned copy of the charge sheet and the materials, my lord, collected by the police. Let it be placed before.
Yes, well, with all respect, my lord, your friend, my lord, and that will not serve the purpose because, my lord, if your lordships granting, my lord, notice, my lord, then I have no objection. But your lordships going further, my lord, to stay, my lord, then I have to clear every fact, man, and from the merit of the case to the legal issues involved, I have to make my submission. But if your lordships give a stay order till framing of the charge, that will also complicate the issue because there is no guarantee that the case will be over till the framing of the charge is there, my lord. At least it will have a bearing on the smooth functioning of the trial
Then
court, my
we
lord.
can do one thing.
At least notice, only notice may be called for, my lord.
It seems that say next date, even if it is on 26th of September, you are saying?
26th of this month, my lord.
September,
Yes.
26th of September is the next date.
Yeah.
But within 26th of September, probability, I'm saying, the probability of the appearance of the other accused
Is
or
because
the
they are
framing of
absconding.
charge may not be there.
Absconders.
So we can fix a date only issuing notice on, say,
Lordship.
maybe on 24th of September.
Yes, then.
That may serve the purpose. I think
Yes.
then in that case, we can hear the matter entirely.
Lord- Lord.
Because the main purpose is you are not, because if you're, if you appear on 26th also, because next date is on 26th, prior to next date, we are thinking of. from
No,
disposing
prior to
the-
that, a date may be fixed, my lord.
That's what I'm saying. If by that time your notice be issued. And we are-
Notice, my lord, the state is there, my lord, so far
State-
the
what is state is there?
informant is concerned, informant has made a party, my lord, at this stage, my lord, may not issue the notice to the informant.
No,
Because, my lord, your,
no, informant is made a party, isn't it?
my lord, normally they say that they have, he has to be made party because he
Like,
filed.
yes, obviously, informant
So
is
he
one
has
of the
been made
party.
party.
Let us, you take steps today itself. If the informant resides where, in Guwahati itself or
No, he is from, my lord, Ghaziabad.
Ghaziabad?
Because each party may be necessary
And
because
he, my lord, on 2 or 3
More
occasions,
than-
he was given the summons, my lord, he didn't appear before the court to give evidence.
more than several courts have been duped of the informant, my lord. That is his, my lord,
As party.
as per the allegations.
No, no, it's
we
not the
do one
crore,
thing.
my lord, it's not the crore, even 1 rupee will may not have a criminal offense, my lord. I am not saying that, not the crore, my lord, because my role in that entire year. My lord, so far Partha Bhardwaj is concerned, my lord, he
No,
did it,
that's
my lord.
why, that's why I'm saying that there are two, the legal issues are being involved. One that is the regarding the part of the investigation, subsequent investigation or the subsequent filing of the charge sheet. Taking the prior permission. And another aspect you have today, you have brought it, if the trial comments deserted.
Yes, my lord, true.
So these issues may be finally heard and decided on 24th itself. But by the condition that we have to make issue notice to the other side. Issue notice, let us see if it comes or if it doesn't come.
No,
then
that is all.
Matter maybe if the.
We'll take the
we
steps
receive
today
the
itself.
Case, the TCR also, that will help Mr. Gusami also to know the.
Yes.
So at present, we are issuing notice and we are calling for the TCR. We are listing it on 24th of this month because otherwise.
24th.
24th of this month, because 26th you are having your next date of appearance.
I know.
If you have any problem, anyway, otherwise it will be after puja only. In that
Can be on
case.
25th, my lord, then.
25th.
My lord, I'll be in the Arunachal bench, my lord, on 23rd.
Oh,
So I'll be coming back on 24th, my lord.
okay.
Let it be on 25th.
Yes, 20. But 26th is the
6
last.
6 will be last date, my lord. your
Last
lordship,
day,
my lord.
last day.
And my lord, I am also leaving to, my lord, my son's place, Calcutta. It's for
I'll
puja
also- I
vacation.
will also be not available.
And my lord, it will not be possible, my lord.
Not possible.
Not be possible because, my lord, the last week will be basically a motion day. That is the, my
Okay,
lord,
then we are fixing it on 25. We'll hear the this legal issues also on that day. And even if suppose no matter if I mean appearance of the informant is required or needed, in that case we can pass an order, interim order at least.
on
To
25th.
that may be helpful. So this time we are fixing it only for issuing notice and.
Bye, bye.
Part Mr. K. Agarwal, the learned senior advocate, assisted by Mr. D. Rajiv, the learned counsel for the petition, and also part Mr. M. P. Park, the learned additional PP appearing on behalf of state. This is an application that is each and its person. So issue notice to the state, notice to the respondents to register AD and usual process. No formal notice is but will served on the state the one number 1. However, a copy may be served during. Also call for the scan copy of the TCL. Please the matter according to 25/9. So we are listing it on 25/9. By the time you take state for the respondent.
We'll take the steps, my lord.
Yes, yes.
They also want.
If it returns after service, then it's okay. Otherwise, it's got.
My lord, your lordship only keep one thing, my lord, that interim, so far the interim pair, will be considered on the next.
Obviously, suppose
Or if,
from
if
an
no order is there, my lord, if it comes to some other court, my lord, then the difficulty will be there.
Okay.
Yes.
prayer for interim may be heard and considered on the next year.
I'm obliged.
May I please your lordship, please? It is the tussle between the father-in-law and the son-in-law. My lord, son-in-law, probably father-in-law might have promised that you get made my daughter, I will give you some property. So probably it was not been able to give because of the property of the father. And now the son-in-law has filed a civil suit at Tezpur that we are contesting. Now subsequently he has filed a criminal case that there was a promise to pay. I have paid money. He is not returning. He is not giving the land also. So he has filed a 420 case and all these things, my lord. There is a judgment of the apex court, my lord, that I am placing. Dispute which essentially is civil in nature, file in criminal complaint. Criminal court's duty to check abuse of the process. While criminal court should ensure that the criminal proceedings are not misused for settling the score of pressurizing the parties to settle the civil dispute. So, my lord, on this score, my lord, my submission is that I take your lordship the complaint case, my lord. It was a complaint case. Police case was filed, but police has given final report that it is not a amount to be a criminal matter. But then he has come for civil, a criminal case, my lord, CR case. Page 12, my lord, I am taking you. Para 2 of the complaint petition, my lord. May I read, my lord? Para 2. That after the marriage, the accused person told the complainant that they would buy a land at Dhekajuli town and construct a shop for him. So the complainant sold his plot of land and for homeopathic shop situated at Santupa Gaon in the district of Morego and got rupees 3 lakhs, which they deposited to the accused person, that is the father-in-law. That the accused person, instead of purchasing land Dhekajuli town, gave 4.5 bighas of land at 2 number Chitalmari village, wherein the complainant is residing by constructing house and is practicing homeopathy on a portion of the land and is cultivating the remaining portion of the land. The complainant again rupees given 10,000, earning from his homeopathy shop cultivation to accused person. At the time of taking rupees 10,000, the accused person also supposed to transfer the said 4.5 bighas of land in his name and converting it to Miyazi Patta. That the accused person, after taking rupees 13 lakhs from the complainant and informant that aforesaid 4.5 bighas of land was gave the complainant to use the adhyar. Thereby the accused person absorbed the rupees 13 lakh. That apart from accused person, they kept the voter ID card, ration card, homeopathic card, license, his educational certificate, assaulted him and threatened to evict him from the said area of the land. At present, the accused person are not allowing to cultivate the said land and the evicting him. The said land filed a civil suit in which pending in the Municipal Court of Tezpur. The accused person involved such conspiracy and absorbed the rupees 13 lakhs from the complainant and by means of cheating tried to evict the complainant aforesaid plot of land. Complainant had lodged the written FIR before the Singri police outpost regarding the aforesaid. The complainant registered, but the investigation officer submitted the final report without doing the investigation. That is, no case was made out. That's why it was filed. He has filed a CR case. So my prayer before your lordship, my lord, he wanted to pressurize the father-in-law to settle the score of their civil dispute by filing a criminal case. I pray that further proceedings may be stayed, my lord.
Cognizance has already been taken.
Yes.
How many accused persons are there?
There are 3, my lord. 3. Father-in-law, then brother, this father-in-law's brother, then own wife, Milan Sarkari's own wife.
Whose own wife? Who is the son-in-law?
Father-in-law is Bhashan Sarkar.
Bhashan Sarkar is the son-in-law.
78 years.
He is son-in-law.
Yes.
Son-in-law or father-in-law?
My lord, petitioner.
Father-in-law.
Son-in-law.
Huh?
A complainant is the son-in-law, my lord.
Achha.
Surya Mohan Biswas.
Milan Sarkar is her
Milan wife.
mother.
Wife,
Wife of whom?
wife of the complainant. And there was a maintenance case, he has challenged in the High Court or he lost. Now he's doing all these things, not paying any amount also.
Heard Mr. S.C. Biswal, the learned counsel for the petition. Not so, petition. To stop, this is an application under section 528 BLSS for quashing the complaint proceeding pending before the Court of Learned GMFC, Sonit Court page 4 in CR case number. No, quashing of the complaint proceeding being CR case number 209 of 2024 under section 406 120B 506 34 IPC in the Court of Learned GMFC issue notice to the respondent to register it in as usual process. Also call for the scan copy of the TCF. Expert considering the submission made by learned counsel for the petitioner. Further proceeding in complaint case number 209 of 2024 pending before learned GMFC Sonitco be state till next day. This the matter accordingly after progress.
May I please, Your Lordship? My lord, this is an application under section 528 challenging the order dated 16/7/2025, whereby the learned magistrate rejected my Jimma prayer, my lord. Impugn order is at page number 32, my lord, and extra 5.
32.
My lord, 32.
So you are praying for Jimma
My lord.
mobile
Jimma
handset and cash amount.
Cash amount of is 2,50,000, my lord.
And that about gold.
My
you
lord,
know?
some gold ornaments. Yes, because I am a jailer by profession.
So do you have any documents?
My
Because
lord,
the,
I have annexed all those documents as well as I have submitted all those documents before the IO as well as the learned court below, but the same were not considered and finally passed this order, my lord.
what nature of case it was?
My lord,
It was a case of what nature?
my lord, theft,
Oh, theft.
theft, my lord. FIR is at page number 11, my lord.
So you claim that those articles are yours.
My lord, kindly for a moment, page number 17, my lord, Caesar list, my lord.
She's from your position.
My lord,
Where is the FIR?
my lord, FIR is at page number 11, my lord. My lord, FIR itself is silent, my lord. How much money was stolen by the, my lord, accused persons, my lord. There is no any specific mention in the FIR itself, my lord.
1 diamond earrings, pair in gold. 1 diamond solitaire ring, gold. 1 wrap earring in gold. 1 pair of gold bangles. 1 hat. Some descriptions are there. Anyway, we'll call for the report, Goswami.
Lordship, because the order is specific that the owner cannot be ascertained because he could not submit any of the documents, man. That is,
If the investigation sees some cash money, what document I can produce, my lord?
and other things.
I have earned those money by mortgaging this loan to extend my business, my lord.
To attend?
My lord, I have earned those money by mortgaging land, my lord, to extend my business, my lord. I am a jailer, my lord. But the police personnel seize this money, my lord.
Other gold items are also there, gold and silver items.
I have submitted the hallmark, my lord.
He has submitted that he being a jeweler, there,
My lord.
those things may be in his
Yes, sir.
possession.
I have
But really, the most probably is that,
purchaser.
that those stolen goods or stolen ornaments were sold in his,
Perhaps that will be the
but
case.
that is the case, I think.
That is a,
Directly, he may not
yes.
involve in committing
the
that, but-
investigation
but-
will.
Okay, we'll call for the report.
My lord, kindly have a short, if possible.
So short, it will help you. Heard Mr. A. Paraman did run the petition, so heard Mr. M. P. Goswami did run a petition, BP appearing on behalf of said respondent. Call for a report from the. and It is not a charge sheet case, I think.
No, no, my lord, not
No.
yet submitted.
Concern
So far as my inspection.
regarding the prayer for of C charges. The additional PP will do in it. Place the matter accordingly. 19, 18, 19, 20. 18 by 19. 19. 19,
Highly obliged.
Madam.
May please the lordship. Lordship here,
If this was what?
lordship
Yes.
here in this case, forest department is required, lordship.
Huh?
Lordship,
What?
forest department is required, lordship.
Forest council will be required, madam. So
Oh, what's that?
I have to
For
inform.
time being, you're saying,
Yes, lordship.
Goswami, try
I,
to just
I
inform.
inform someone.
We try to inform.
Time being, lordship.
May it please, Your Worship.
Yes.
My lord, this accused petitioner, my lord, he was facing a trial in the lower court, and the trial court acquitted him on merit.
This
And
is the
yes,
petitioner.
acquitted him, my lord. That order is at page 20. Lords will find at 31, page number 31. On the ground that PWs have not turned up for many dates, therefore allegation against him was not proved. So on merit, my lord, this judgment was passed and the accused was acquitted. And apparently, my lord, this acquittal is under section 248 of the CRPC. Now, my lord, the other side, my lord, the informant side, informant victim, my lord, at that point of time would have only two redressal. Either they, the district magistrate can ask the learned public prosecutor to file a appeal against acquittal under 378, or the victim can approach under 372 by way of an appeal against acquittal. So now, my lord, it is specifically clear, my lord, 401, when appeal lies, no revision lies. Revision will only lie when there is no appeal. So in this case, my lord, this particular aspect is under consideration. This the other side, my lord, file a revision, victim. So my humble submission is this, my lord, when there is a provision of specific provision of appeal, either under 378 or 372. 378, I understand, my lord, DM has not gone for appeal. So 372 was the proper provision of law where she could have appealed before this honorable court. Now, my lord, revisional court, when there is a provision of appeal, could not have entered into the merit of the case and but this pass this impugned order, my lord. That yes, the court below, my lord,
Yes.
at page number 45, paragraph 21, has that is the finding, my lord. The informant victim shall appear before the learned trial court along with the identity and proof, even without service of any formal summon used upon her on date fixed for the learned trial court. On her appearance, the learned trial court may examine the informant as PW on the very day or may give another date for her examination. This is where we are aggrieved, my lord, because I have been acquitted under the provisions of law for 248. So definitely, my lord, if anything, revision does not lie against that particular judgment, my lord. Law is
Whether
absolutely,
any merit was discussed there?
yes, my lord.
Merit is not
Merit was discussed. The
4-0.
divisional court has set as an appeal, my lord. Appellate
4-0.
court.
That is what I mean.
Yes. On merit, my lord, this decision was taken, my lord. That points for determination and all this.
No, this is to consider. I'm on the other order where the
First
acquittal was
order.
passed, yes.
First order,
Acquittal is at page 31,
first
my lord.
order, my lord, merit is not taken care of. The first order.
It says, my lord, the court below said, my lord, that trial comments and the page 31, para 2, my lord, trial comments and the prosecution could not secure the attendance of even one witness to this court. And the matter has been pending for evidence since 6/6/2022 for the testimonies of the prosecution witness. As such, in the interest of justice, the court closes the evidence of the prosecution as no witness were examined. The SD has been dispensed with. The point of determination in this stage is whether the accused, being the husband of the informant, subjected her to mental and physical cruelty that thereby committed an offense punishable under 498 of the IPC. As no witness testified against the accused, the charge stands disproved against the accused. My lord, what I understand, my lord, on merit, this order was passed, not on default. So apparently, my lord, the acquittal has to be under 248 of the CRPC.
Oh. Is there
Because it's
any discussion on merit, Goswami?
Well,
What you have, sir?
yes, ma'am, regarding the, my lord, why, my lord, the entertaining of the revision petition by the session judge, my lord, session court. That has been discussed in page 41, my lord, page 40.
40?
Page 40 from paragraph 12, my lord. Regarding the maintainability of the petition.
Because we have raised the question there, my lord, maintainability also. Four 38 to 4. 248. Oh, Minister. It was something renewable. That's not a bill to. May I just point out one thing, my lord?
It was basically a complaint.
Yes. My lord, here, if we go by that, my lord, if it would have been a complaint case, then my lord, directly 378 victim could have approached under 378. But my lord, since it is is instituted by way of an FIR, my lord, then my lord, the DM is entitled, my lord, but he has the power to direct the public prosecutor to file an appeal. So, my lord, here, if that was not done, the only way out is that, my lord, 372 to the same court, to the divisional court itself, my lord. It says, my lord, 248, acquittal or conviction, my lord. 248, my lord. It says, if in any case under the chapter in which a charge has been framed, the magistrate finds the accused not guilty, he shall record an order of acquittal. Where in any case under the chapter, the magistrate finds the accused guilty but does not proceed in accordance with the provision of the section 325 or 60, he shall, after the hearing the accused on the question of the sentence, pass sentence upon him according to law. Now, my lord, after 248, the proper procedure, my lord, TM could have, my lord, asked the public prosecutor to file an appeal in the revisional court, in
It was a
the,
complaint case, huh?
yes, no, in case, my lord, 378. 378, when it is not a complaint case, then the DM is authorized, my lord. (378), my lord. The district magistrate may, in any case, direct the public prosecutor to present an appeal to the Court of Session from an order of acquittal passed by a magistrate in respect of a cognizable and non-bailable offence. Very clear, my lord. So
Yeah,
if
that is the question is that this is the case of complaint case.
no, this is FIR.
FIR is.
FIR.
What?
FIR, my lord. Complaint, then, my lord, 370 would have squarely come. But FIR was filed, my lord, charge-sheeted, thereafter trial commenced, my lord, and the learned magistrate acquitted under section 428, or 248. Yes. Now, my lord, 372, that would have been the proper forum, my lord. Otherwise, my lord, 372 says, my lord, provided that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offense or imposing inadequate compensation, and such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction of such court. So the proper, my lord, forum would have been under 372. Appeal to the Sessions Court. Revision is for, my lord, impropriety, my lord, for glaring defects, my lord, on the face of the record. And where no appeal lies. Now, my lord, the last part of the judgment, my lord, in the revision, my lord, we are agreed by that, my lord. Again, my lord, if this impugned order remains, my lord, judgment remains, then again I will be, my lord, with the same jeopardy, my lord. I have to face the trial again.
Yes, Kusami.
Yes, madam. And normally, my lord, in a case under policy board, my lord, the acquittal, my lord, it has to be, my lord, appeal. There has to be an appeal in the session, my lord, if it is by the CGM, my lord, magistrate court, my lord. And section 372 also says that it's a right of the victim to prefer an appeal.
Yes.
372 provides a, my lord. Normally it is there, my lord. But as per the
Yeah,
trial court, my lord,
question is a bit different because it is not a case on merit was not disposed of.
yeah,
If you go by the order, it is not a case that the merit was not discussed or not disposed of on merit.
yeah,
Simple order that because of absence of the witnesses,
witnesses
the order was passed.
passed.
And the consequential order will be the acquittal. Otherwise, what order will be? Either discharge or acquittal.
Acquittal.
Against that order, this validity or the impropriety of the order, against that only they have moved for under 390.
399,
That is maybe the one aspect.
that,
Yes.
my lord.
And
And,
because
yes.
it's not a case that because no merit was discussed. That
Yes.
was the only point of that.
Yeah.
So whether that order passed by the acquittal order was correct or not,
And that is, that part,
That part.
whether any
was-
farmers regarding the.
My lord, without
Purpose
taking
that
much
is-
time, my lord, I just pray before your lordship, my lord. My lord, because that particular
So now when your case is fixed? in present-
that is what, my lord, page 21, it says, my lord, the victim can appear and further go for PW. So this will be, my lord, very prejudicial to me, my lord, because I have been acquitted, whatever, my lord, what I have been acquitted under certain
So now
sections
you
of.
have received the summon.
Not yet, but we are apprehending. Because it is specifically, my lord, stated that along with her identity proof, even without service of any formal summons, upon her date fixed for the learned trial court, on her appearance, the learned trial court may examine the informant as PW on the very day or may give another date for examination. But my part is not there, my lord. Again, I have to be summoned, my lord. I have to go for cross-examination. This order is somewhere, my lord, not appropriate, my lord. That is why I just pray before lordship, my lord. Let
So
this
the order was passed on 18/6.
18/6. So, my lord, I just pray that this order may be stayed and this matter may be, my lord, finally decided. Because this issue is always there, my lord. Whether a appeal lies or a revision lies, these things, my lord. So it has to be clarified, and I will substantiate with judgments also at the time of hearing, my lord. At this stage, my lord, my appearance may not be, my lord, that this impugn order may be stayed. Finally, if, my lord, either side, my lord, we'll come to know, my lord.
Heard Mr. T.H. Hadari, return with counsel of the petitioner, also heard Mr. M.P. Goswami, return assistant people so and so. He sent an application. Under application 548 BLSS
Date of FIR.
for setting aside generation,
FIR.
washing of the impugned judgment and order dated 18/6, which is already passed. Revision number 43 of the 2020 by learned dispensation judge number 5, issue notice, the respondents. Next matter, considering the submission made by the learned counsel of both states and the nature of the case, I find it necessary, I find it, nature of the case, the execution of the order of impugned judgment and, the impugned judgment and order dated 18/6/2025 be stayed, public suspended till next. This matter. We are staying the matter.
Deeply obliged, my lord, deeply obliged.
Courts. For example.
May I please, sir?
Yes.
Lordship, here in this case, Lordship, the present petitioner is the son of the registered owner, Lordship. Registered owner.
Son of the
Registered owner. He was died, Lordship. Registered owner was died. Lordship, kindly come into page 15. That's the RC. Registration certificate of the track, Lordship. Here, Lordship,
I mean, petitioner's father was a registered owner
owner of the
tract.
track, yes.
That has been seized. I think.
See, yes, Lordship. And the registered owner's Lordship was died, Lordship. And ultimately, Lordship, next of kin certificate is I already annexed, Lordship. And that track has been seized. Confiscating procedure has been drawn. Everything has been completed. Petitioner was challenged before the Supreme Court, and Supreme Court has been rejected. There is an observation as given. Lordship, kindly peruse this Supreme Court order, Lordship. That is page 27. Supreme Court says, Lordship.
Page 27.
27, 11 page portion is 28. And second paragraph of Lordship, after 7 lines. After 7 lines, this finding has been affirmed.
Yes.
This finding has been affirmed by the High Court by the impugned judgment. While affirming this view taken by the district judge, the High Court has relied upon a decision of this court in the case of State of Karnataka versus Sangso, wherein this court held that when any vehicle is seized on the allegations that it was used for committing a forest offense, the same shall not be normally returned to a party till culminations of all proceeding in respect of the SASA. Culmination of the all proceeding. Here, Lordship, in the meantime, what happened, Lordship? The charge sheet has been submitted. That is page 30. 11th portions, Lordship, 31. Take last paragraph. There it mentions the accused name, Lordship, Deep Kumar. And Lordship, track number, Lordship, is there. So ultimately, Lordship, cognizance has been taken and their case has been withdrawn, Lordship, and accused has been acquittal on withdrawn. Kindly come into page 33. Order dated 27/3/2023, Lordship, that order has been given. The peruse the petition bearing number so filed by the learned APB so filed under section so praying for withdrawal of this instant case as per the notifications number so dated 21st October 2020 of the Assam State of Assam. Peruse the case record. On such perusals, it is found that the IO has laid the charge sheet in this case under section 41 of the Assam Forest Regulations against the accused. Heard learned APPE. It also reveals that the case does not fall in any of the exceptions as mentioned in this above state notifications. Moreover, it is also found that the matter fulfill other criteria mentioned in section so. In view of the above fact and circumstances, the player is allowed. The case is accordingly disposed of on withdrawal. This article, actually, that is important. This article, if any, shall be disposed of in due course as per law. The accused is hereby discharged. Lordship, when this order came into knowledge, the accused, he was the power of attorney, Lordship, was given the registered honor. He has filed under representations. That is page 34 before the Forest Department, Lordship. Against these representations, he was approached before this honorable court. That is page 35. And during this pendency of these petitions, Lordship, the petitioners are dying. That's why, Lordship, the peasant petitioners, he is the son of this registered honor. He has approached before the Forest Department to release this vehicle as because all the proceeding has been completed. There is the page 38, Lordship, that representations. Lordship, one more thing, Lordship, page 39, in this order of this honorable court, same footing, on the same day, 2 vehicles seized, Your Honor. And same order has been given.
This
ultimate
against the High Court order also you moved in SAP before the Honorable Supreme Court.
Lordship, there is a
When-
confiscating procedure. I am not saying that whatever confiscating procedure has been drawn, that is closed. Later on, what happened, Lordship?
No, this High Court order is before confiscation, after confiscation, when it is.
Lordship, I am saying, Lordship, when confiscating order was passed, that order has been challenged before this honorable court, along with this Supreme Court. All the petition has been rejected. So now present petitioner is not coming against this order, Lordship. I am coming, Lordship, that in the meantime, all the proceeding before the court below has been concluded.
But why didn't you we brought all these things before this court while passing the order on 28/4/2025? You remain silent regarding the withdrawal and all?
No, Lordship. Lordship, kindly page 35. Kindly come into page 35.
Complicated.
No, Lordship, there is no complicated, Lordship. I am extremely sorry. I think I am not presented my case. That's why, Lordship. Lordship, my submission is that, Lordship, kindly come into page 35. when Lordship present, when all the proceeding has been completed, then the accused was approached before this honorable court to release this vehicle.
So what was the order then?
Lordship, during that pendency of the petition, that is the page 35, that petitioners were died. So, Lordship, it is reflected page 36.
Then died, yes, 36
Okay.
reflected then.
So, Lordship, that's why when the petitioners died, Lordship, the present petitioner, he is the son of the registered owner. He has approached before this forest department saying that all the proceeding has been completed, so the vehicle may be released.
But vehicle has already been confiscated.
Lordship, that was Lordship. If Lordship initially,
Yes, sir, Botaku, he is not, I'm not.
Lordship,
following you.
I have received the petition today, my lord. So I want to go through it. But if 1 week's time, maybe.
Lordship, one more.
Both in one hand, he is submitting that yes, obviously there's an order of withdrawal is there. That apart that the confiscation and proceeding along, he moved to the Supreme Court also.
Yeah.
And Honorable Supreme Court had passed out order
Dismiss.
considering the order passed by the High Court. in fact. So now at this stage, I don't know, and he is also submitting that confiscation proceeding, etc., has already been completed.
Lordship.
So that is why, I don't know, so you can take,
So, my lord,
proper take instructions
yes,
before
I'll
the
take-
department concerned.
Yes.
So what is the stage, whether the case has been already been, his withdrawal is there, withdrawal
Yes.
part is there. And now this present petitioner claiming himself to be the son of the registered owner. Earlier, who was the petitioner?
Yes.
Your father was also an accused there?
No, sir. Your Honor, my father was not accused. That my father was given a power of attorney to one Deep Kumar to manage or supervise.
That fellow was a
He was the Deep
accused.
Kumar was the accused, and he was acquitted, and ultimately
acquitted on the basis of withdrawal.
withdrawal. Yeah. Ultimately, Lordship, he was approached before this honorable court. During the pendency, he was died.
Yes, sir.
And take instruction, otherwise.
Yes, sir.
it's,
Lordship,
complicated.
Lordship, one more thing, Lordship. Kindly peruse the page 39. Same
Where
order,
is it?
similar, same day, two vehicle was seized from the Deep Kumar. One is he himself is a registered owner, and another is this power of attorney holder. Whatever registered owner own vehicle has been released by this honorable court. That is page 39. Same footing, Lordship, everything same.
Hmm.
And a Lordship law is very much clear. Initially, whatever confiscating procedure that is temporary. Law is saying that, Lordship, when the petitioner is convicted, then, Lordship, the convicted court has given an order to confiscations. So then that property is completely goes to department. Then it is permanent, Lordship. Regulation 51 and 52 is very much clear. So
Okay,
my submission is
You
that
take just instruction you take, what about is in the custody vehicle at present? And just give us details. Because he is not in a position to submit anything at today. So we have received a copy of the order, copy of the case petition? Copy of the petition you have received?
I have taken PP's copy, but I have not been officially served. The council is saying that he served me, but we have not received. So my lord, the council may submit a furniture.
PP is otherwise also there.
Yes.
And Mr. I hope the Learned Council for the petition. Also heard Mr. I bought a good. Learned Council appearing standing council. You are now standing council forester now you are or
On behalf of my lord, special PP wildlife.
special PP wildlife. Also heard Mr. Other Kaushik, the learned additional PP appearing. To order appeal from this application students video given now. It is submitted by Mr. Board that he needs some time to take proper instruction. In considering this aspect of the case, let the matter be listed. After 1 week will do, or you won't need any fixed date?
After 1 week, ma'am.
After 1 week?
no, Lordship, kindly given a date, Lordship. Otherwise, now
Then it will go up to September, last of September.
Lordship,
Because we
otherwise-
don't have, because what I'm saying, if the registry can manage, then definitely they may accommodate the court. Otherwise, we don't have any date. We are already full. So in that case, your petition, your matter will be listed maybe on 19th of September.
Lordship, can it be 20, Lordship? 21st or 22,
21st, these are all holidays.
23rd, Lordship.
23rd, okay, 23rd.
File your best.
Okay.
May please, your lordship. Yes.
May I please?
Yes.
Lordship, in this case, we have challenged the order dated 24/6/2025 passed by the learned additional session judge 3 of Kamrup Metro. Lordship, by which Lordship, Zimma of a vehicle that was seized in connection with an offense under the Customs Act was released by the learned court.
Who is appearing?
No one is appearing, Lordship.
No. The DRI council any? anything has
I'm
any
appearing
counsel?
for the DRI, Lordship.
Oh, sorry, you are appearing for
Yes,
the
yes,
DRI. Okay. Okay. Yes,
Lordship,
then?
this learned court had allowed the Zimma application of the respondent, wherein a vehicle that was seized in connection with an offense under the Customs Act was released by the learned court. The facts of the case is that, Lordship, on 17/2/2025, an intelligence was received by the office of the DRI that a consignment of foreign origin cigarettes will be transported via Guwahati, Lordship. Thereafter, immediately upon receipt of the transportation, the DRI officers went to the place of interception at Jorabat and had intercepted that particular vehicle where that foreign origin cigarettes were loaded. Thereafter, Lordship, further proceedings were conducted. Those persons who were involved, they were arrested, and the vehicle where those consignments were loaded, that was seized by the officials of the DRI. Thereafter, Lordship, the respondent in this case had moved the Zimma application before the learned court, and the learned court had ordered to produce a report by the IO before the learned court. So we had produced the report on the particular date, and thereafter our report was not considered. We had raised an objection that the learned court has no jurisdiction to order custody of a seized article which has been seized in connection with an offense of the Customs Act. Because Customs Act itself contains a self-contained mechanism for seizure and release of the seized goods that are seized in connection with Customs Act, Lordship. Your Lordship will find the order dated 24/6/2025 at page number 45, Lordship. Annexure 3. May I read it, Lordship? Today, date has been fixed for passing order on the Zimma petition. This is an application filed under section so-and-so BNSS by the petitioner Syed Ali Laskar, saying for Zimma of the vehicle truck bearing registration number so-and-so, chassis number so-and-so, engine number so-and-so, and model Ashok Leyland so-and-so, which was seized in connection with DRI case number so-and-so of the Customs Act 1962. By the said petition, the petitioner has submitted that further detention of the seized vehicle may not be required. The learned counsel for the petitioner has submitted that the truck involved in this case is required for the daily livelihood of the petitioner. And in view of the judgment passed in Sundarbhai Ambalal Desai versus State of Gujarat 2002, the learned counsel prayed to allow the Zimma of the seized truck in the custody of the petitioner. The DRI has submitted objection through their intelligence officer and prayed not to give the Zimma of the seized truck to the petitioner. The learned special PP for DRI has submitted that in view of section 110A of the Customs Act, this court has no jurisdiction to dispose of the seized vehicle, and only the Joint Commissioner of Customs Preventive Northeast Region Shillong has the jurisdiction to dispose of the prayer for Zimma. The learned special PP has further submitted that the vehicle cannot be granted in the Zimma of the petitioner for the prayer made under section 497 of BNSS, as the vehicle was not produced before the court. It is immaterial whether petition under section 497 or 504 BNSS has been filed. Whatever be the section, this court has the power to dispose the petition as per the law contained in Sundarbhai Ambalal Desai versus State of Gujarat 2002. Peruse the section 110A of the Customs Act, which provides for releasing the seized materials by adjudicating authority or by the proper officer mentioned in the section. However, there is no bar in the said section about the disposal of the petition by the court. It appears from the record that the vehicle was seized on 18/2/2025. Since the date of seizure, the DRI authority has found sufficient time to investigate the case along with the vehicle. In view of the above, the prayer made in the petition to give custody of the vehicle to the petitioner is hereby allowed. The petitioner, Syed Ali Laskar, then thereafter, Lordship, certain terms and conditions were imposed and the vehicle was released in favor of the respondents herein.
So it
The
has
Lordship-
already been released now, or
Lordship, it has not been released till now
Till
because we have preferred an application before this court challenging this particular order. Lordship. The Lordship will kindly have a look at the seizure list at page number 41, Lordship, annexure 2. Total cigarettes that were recovered were 19,85,000 sticks of foreign origin cigarettes, amounting to a total of rupees 3 crores 37,45,000 rupees. And thereafter, at page number 42, your Lordship may have a look at serial number 4, Ashok Leyland truck model. This was the vehicle for which they have filed this Zimma application, filed that Zimma application. Now, my humble submission is that, Lordship, the learned court had no jurisdiction to grant an order of Zimma for the release of the seized vehicle in view of the provision contained under section 110 and 110A of the Customs Act. Lordship may kindly have it. I'll just read the main portion, Lordship. Section 110, seizure of goods, documents, and things. If the proper officer has reason to believe that any goods are liable to confiscation under this act, he may seize such goods, provided that where it is not practicable to remove, transport, store, or take physical possession of the seized goods for any reason, the proper officer may give custody of the seized goods to the owner of the goods or the beneficial owner or any person holding himself out to be the importer or any other person from whose custody such goods have been seized, on execution of an undertaking by such person that he shall not remove, part with, or otherwise deal with the goods except with the previous permission of such officer. Lordship. This is 110, and Lordship may come to 110A, 110A of the Customs Act. This deals with the provincial release of goods that are seized in connection with an offense of the Customs Act. Any goods, documents, or things seized or bank account provisionally attached under section 110 may, pending the order of the adjudicating authority, be released to the owner or the bank account holder on taking a bond from him in the proper form with such security and conditions as the adjudicating authority may require. Now, the provincial release of such goods, Lordship, which are seized by a custom officer, is entirely a quasi-judicial exercise, Lordship. The court has no jurisdiction to interfere with the release of the seized goods, Lordship. Now, another aspect is that, Lordship, since this Customs Act is a special statute which provides a self-mechanism for release of such seized goods, it will override the general law that is contained under CRPC or BNSS. Lordship may kindly.
okay,
This case is covered by a judgment of the Honorable Meghalaya High Court, Lordship, if I may, Lordship. Similar case, Lordship. Facts of the case are similar, Lordship. In this case, what happened that 2 trucks were seized by the DRI Shillong Regional Unit, Lordship, for an offense under the Customs Act. Thereafter, the respondents, they had moved before the Learned Court of Judicial Magistrate First Class, seeking Zimma of the seized trucks. The Learned Judicial Magistrate First Class had allowed the Zimma upon executing a bond of rupees 1 lakh each. Thereafter, the DRI had filed a revision application assailing this particular order before the Learned Session Judge, who later on upheld the order of the Learned GMFC. Thereafter, the learned department aggrieved by that particular order had challenged this particular order of the learned JMFC and the session judge before the Honorable High Court. Lordship may kindly peruse paragraph 18, 19, and 20. Lordship, paragraph 18. Similarly, identical case, Lordship. Coming to Customs Act 1962, what is seen is that there are specific provisions for searches, seizure, and arrest under Chapter 13 of the Act, which empowers the proper officer to resort to the provisions of Section 100 to Section 110A for the same. However, for the limited purpose of this matter, the relevant provision would be Section 110, which speaks of seizure of goods, documents, and things, and Section 110A, which provides for release of goods, documents, and things seized pending adjudication. For the sake of clarity, the above mentioned provisions are reproduced herein. Lordship may kindly have a look at the next page. Lordship. These are the provisions which I have just read. Okay. In a proceeding under the Customs Act, it is but natural to expect that the provisions of the said act
Okay, then
would.
we'll hear after
Lordship.
fix. Or otherwise, we do one thing. I have come up to your.
Lordship, I have
conclusion.
just a limited prayer, Lordship. At this stage, notice may be issued and my interim prayer may be accepted, Lordship, till
For
the next
stay of the
returnable
date.
date.
Stay out.
Yes, yes, Lordship, till the next returnable date.
Mr.
And
K. Brook.
trial court records may be required, Lordship.
Mr. K. Brook, the learned Standing Council DRI. This is an application. And section 28. Read with section 442 and 438 of the annexes for setting aside and quashing of the order dated 24/06/2025. Passed by the Court of Learned Additional Session Judge FTC number 3, Kamrup M. Guwahati, in this case number 133 of 2025, corresponding to DRI case number 26/CL/IMP CIG DRI GJADU /2024-2025 dated 18/2/2025. Issue notice to the respondents to register AD as usual process, no further as usual process. And also call for the TCR of court. Want to call for the TCR of both this
Yes.
additional session just or
Yes, additional session. It's what I have learned is that it's pending before the additional session judge 3. Case records are
TSR of the scan copy of the TSR of additional session that FTC. It is for the submitted to Mr. Brook that the tracking question which was intercepted during investigation of this case was carrying once a year cigarette of foreign origin. According the case has been registered. But during the balance of this case, a petition was filed by the respondent seeking Jima of the vehicle, wherein the department also filed their written objection, but without considering the objection and the provision under section 110 and 110A of the Customs Act, the Jima order of Jima has been passed, releasing the vehicle in favor of the respondent. He further submitted that the customs that he submitted that the relevant provision section 110 and 110A speaks about the seizure of goods, documents, and things, and their release of and their release accordingly. But he is a special act, and the authority concerned has the special power for search, seizure, and release of the vehicle. Mr. Brook accordingly submitted that the prayer accordingly prayed for an interim relief and prayer and for an interim relief to for stay of the execution of order dated 24/6/2025 till the disposal of the present application. Next, madam, considering this submission made by Learned Standing Council BRI and other aspects of the case, the execution of order dated so and so is stayed till next date of listing. This the matter according to okay.
Privilege.
Yes, Lordships. This criminal division I have filed against an order dated 18/11/2019 passed by the learned judicial magistrate first class, taking cognizance of an offence for under the section 130 in the Act. Now, my lord, before that before reading that portion of the order, I just want to go through in brief, the facts of the case. In 2014, the petitioner has issued 5 checks amounting to rupees 21 lakhs to the respondent number 2. Respondent number 2. And the account which was maintained of the petitioner was in Morigaon district. And these checks were issued to the respondent number 2, who has an office in Guwahati. That's why he has presented all the 5 checks in Guwahati, 2014. And initially, after that, after that, what happened? All the checks were bounced. Accordingly, notice were issued. And accordingly, initially the case was registered in Guwahati in the year 2014. But my lord, what happened? This is Dasharath Rup Singh Rathod versus State of Maharashtra. The case, once it was listed in Guwahati, the learned judicial magistrate Kamrup, what he did, had order dated 29/11/2014 was pleased to return the complaint case to the respondent number 4 to file in proper jurisdiction court. Because in that, that judgment, it said that it has to file where the check was issued, where the petitioner maintained the account. That's why the case was transferred to judicial Morigaon district. After that, what happened? The case was then again listed into 28/1/2015 before the Chief Judicial Magistrate Morigaon. It was transferred. And Chief Judicial Magistrate referred the case to Judicial Magistrate because he cannot take up. He referred the case to Learned Judicial Magistrate Morigaon, it being case number 128 of 15. So in page 8, my lord, I have annexed that all the dates, my lord, of the order. What happened if your lordship go through all the dates, you will find that if you peruse the order, in 3 occasions, the complainant was absent without taking any steps. That is why the matter was sent by the judicial magistrate to respective Lok Adalat. But the matter could not be resolved in Lok Adalat. So it was again referred back to the judicial magistrate Morigaon. And then after that, what happened? The judicial magistrate Morigaon, taking cognizance of the offence without going through the evidence without filing in any evidence of or initial deposition, he has taken cognizance.
Without
initial depositions and without evidence on affidavit, he has taken cognizance. I have stated. Now what happened? Without taking, this is the first mistake. Then what happened? After that, my lord, what happened? Therefore, on 22/4/2015, 29/7/2015, 87, the respondent once again remained absent without any steps. The respondent means the complainant has remained absent. So, as per decision of the Honorable High Court, since that time the NIA case cannot be tried by a judicial magistrate, so it was referred back to Chief Judicial Magistrate. I have referred their petition for the basis submitted. In the meantime, the complaint case was transferred by the Learned Chief Judicial Magistrate in accordance with the direction of Honorable High Court
case instituted under negotiation data to be tried by learned chief judicial or additional CJM. Upon receipt of case record, the learned CJM Moriga was pleased to fix the matter for Nishi order on 2010-2015. Then what happened, my lord? This is I have annexed that document. In 2015, 2010-2015, that is annexure 5, page 67, my lord. If you also just page 67. Now see what happened. Page 67. Both the parties, you will have to go through here, page 67. Both the parties are absent in stage for a long time. Hence, this case has been filed. Has been filed until further order. This is customary. It's filed. System is not that. It should be distinct. So, taking advantage of this order, the complainant suddenly jumped into the fray and he filed a petition on 1/6/2027 for transferring the case to Guwahati because of the amendment in Negotiation Instrument Act 2015. And that petition that petition number 4297, 4279/17, Annexure 6, my lord. If you also go through the Annexure 6, page 69. An application under 142A or the Negotiation Instrument Act amendment of praying for transfer the case again. That case was already filed. But suddenly he has, without restoring or something like that, he has filed direct petition to transfer the case. Another case, another time, and the necessary order was passed in Annexure 7, page 70. Page 70. The London Chief Judicial Magistrate passed the order. Case was put up before this court in terms of order dated so and so, passed in the body of petition, filed by the petition London Council, praying for transfer the case to London CJM Metro on the point of jurisdiction. In view of the Negotiation Instrument Act, peruse the petition and case record. The petition reveals that due to passing of Amendment Act, the district has no jurisdiction in the case. The point of jurisdiction may be raised before the London Tribunal Court as the case is not pending before this court. This case record to trial court for consultation in this regard. PSL takes it. So what about the restoration? No restoration, nothing. He has filed a petition, transfer, and the court also passed an order like this. Then what happened? He realized that there is a mistake. So he filed a petition again on 4/1/2019, that is Annexure 7A, page 71. Page 71, application praying for revival of the case. Revival, there is no word in CRPC for can it be revived? Now for revival of the case, then what happens? The Chief Judicial Magistrate very minutely do it. Page 74 is the order of the Chief Judicial Magistrate. Case is put up on one Jyotirendra Kumar Singh, who is the authorized representative of the complainant, praying for revival of the case. Peruse the petition and case record, hard learner counsel. We have high ordered for non-appearance of parties. The case was filed under further order. Further order, inherently, it was ordered the point of jurisdiction may be raised before the London trial court as the case was not pending. However, perusal of the previous order reveals that while ordered so the case was received by the court for disposal. Today, while aforesaid petition, therefore, the complainant by citing the Negotiation Instrument Act, paid for transfer of the case. The offence and section required and tried only by a court within the location structure. For this purpose, the clause. Now, what is the order? Now, in view of the aforesaid provision, which has been amended, it appears the Court of Judicial Measure first class shall have exclusive jurisdiction to try the alleged offence under hence the case record. Return the case to the complainant for filing before the proper court. Memorandum return to be prepared and original complaint shall along with all the query return to complainant after obtaining his London Council signature under the return memo. The return memo is kept in the office. Have you gone through it, my lord? Page 75. Have you gone through it, my lord? Page 74, 75. Now what happened? So the London Chief Judicial Magistrate, technically he has made a mistake. He has not, neither he has the power to revive, and he is totally in this silent. Neither he revived the case because he knows he has no power to revive. And what happened? He simply directed the case to shift to Guwahati. And Guwahati also, what did he? Now, what happened? I'm telling, the legal point I'm telling you, I'm telling. The complainant, what happened? On 4/1/2019, thereafter on 4/1/2019, page 12, I've read my note. Page 12, para 8. Page 12, para 8. The petitioner begged to submit that thereafter on 4/1/2019, the respondent complaint against filed another petition before Honorable CJM Morigao, praying for revival of the aforesaid complaint case, also for transfer of the case. The said petition filed by the respondent number 2 complaint was accordingly numbered as petitioner so and so. The petition begged to submit that thereafter case record put before the landed CJM Morigao, and landed CJM Morigao filed his order dated so and so was pleased to allow the payer of the respondent number 2. Accordingly, the said order direction was given to respondent number 2. Given to return the case record to respondent complaint to file it before the proper court. It is pertinent to mention here that no specific adjudication was made on the aspect of revival of the complaint case. The order dated 4/1/2019 passed by Landed is silent as to whether the complaint case to revived or not. As such, the prayer for revival remain unaddressed or undecided. It is further submitted that without reviewing the complaint case to judicial order, the case record was returned to complaint, thereby resulting transfer of the case in absence of any formal order. Now, it was now then what happened? That case was placed before the CJM Guwahati. CJM Guwahati on 5/2/2019, para 9. That petition begged to submit it thereafter the case recorded so and so was placed before the Learned Council of the respondent of complaint before the Learned CJM Guwahati on 5/2/2019. Thereafter the Learned CJM Guwahati had order dated 5/2/2019 was pleased to transfer the case record to Learned JMC Kamruk Metro Guwahati for doing the needful in accordance with the fixing so and so for appearance. Therefore, the case number was renumbered as this is the present case, CR 449 of 2019. That petition begged to submit the thereafter renumbered case now listed before the Learned JMC Guwahati on the following dates. This is the dates. Now, para 11. The petition begged to submit the thereafter on 18/11/2019. This is the impugn order. The respondent number 2 company has filed the initial deposition on respondent number on affidavit under section 200 CRPC of the enact. The Learned JMC had order that so was pleased to take cognizance of the offence against the accused under 138 of the enact had order that so and so. And also issued summoned upon the petition upon director respondent come to next stage. They have a fixing 18/1/2020 for appearance. It is also opposite to mention here that there are no allegation against the petition number now. What happened? Now come in the merit of the. So this is a technical, we have made a mistake.
So now what is the stage of the case? Where
What
it
is-
pending? It is
yes, my
pending
lord,
before JMFC Guwahati now.
Guwahati
And what is the stage of the case?
state of the case is that, my lord, it is fixed for again that initial deposition, the person who has made the initial deposition, he died. So another person has appeared, and again the court is going to take cognizance of this offence. Once it is already cognizance, the court has again fixed the date for fresh initial deposition and fresh cognizance. Is this possible? Is it
No,
possible?
see, question is that on this jurisdictional point and all, the case has already entered, case record has been returned
Yes.
with a direction to the complainant that
Yes.
you file the case in a
Yes.
proper forum.
Forum.
So accordingly, he filed it in a proper forum. So
Forum.
there is no existence of the case record earlier filed before the learned CGM Morrigan.
Yes, my
So
lord.
that's why you have to take cognizance.
Now-
So you have to record the
Yes, my lord, what happened, my lord?
200 or 202 CRPC.
Yes, yes,
Otherwise,
202.
how can the
Yes,
court of
see, already
Guwahati can
200
take cognizance?
How 202 CRP they already recorded and taking 18/11 to 2019 the court has already recorded the statement.
Who? JMFC Guwahati or who?
JMFC Guwahati.
Then what is the problem now?
Now what happened? Now I'm telling you, my lord. In specific, the only thing is that, my lord, I'm coming down legal point. Specific provision is must be there in the CRPC that they enact that the allegation has to be, which is a company. So it has to be, that allegation has to be made directly against the director of the company. But there is no averment. If you lordship go through the complaint petition, there is no averment as such that the partition is liable for vicarious liability. No allegation and take, and the court has to take cognizance against the director.
This will definitely come, but you are questioning it. Since then, we are 15 minutes, we heard you.
Yes.
Now you are simply submitting that these kind of things were there, then posted were here, and then it was filed and it was survived.
Yes, because this is all
But
the
those
technique.
cases are not in existence now. The existence present case is before the learned CGM, wherein he took cognizance after recording 200 and 202.
Two, and 200
Now against you, whether there is a case
made out or not.
I mean, made out,
Because-
that is other aspect.
Yes,
The
yes.
question is now those
Yes.
things are not here.
Yes, yes, yes. Now, there is no proper allegation. I have stated there is no proper allegation, particular allegation against the director of the company that he is responsible for day-to-day affairs of the business. First thing. Second, there, as per enact provisions, 138B, the payee or the holder in due course of the check, as the case may be, make a demand for payment of said amount of money by giving a notice in writing to the drawer of the check. Within 30 days, receive information by him from the bank regarding the return of the check as unpaid. So it is very important that notice has to be issued. But in my case, the notice has answered.
Page 50.
Page 50, if you also give to page 52, their averments. Page 52, page para 6.
This is a complaint petition.
This is where in the complaint petition. The notice addressed to 1 to 5 were delivered on so and so as per AD card received after service notice, whereas the notice addressed to accused number 6 came back without service. So when it came back without service, so how the court can take cognizance of the offense? This is second part. First part is that there is no specific allegation because there are a lot of judgment. I can catena of judgment is here, where you have to state specifically the vicarious liability part. Where is this specifically stated?
Come to para 50, page 52, para 7.
Para 7. The accused person and others are aware of the legal notice dated so and so, and as the representative of the accused company also visited the office of the complainant after receiving legal notice, but in spite of that, accused have not paid the amount covered by
So
this.
why are you saying that if notice is not served?
No, notice is served, but what about the
Point number 6.
respondent number 6, accused number 6? Para 6, para 6, para 6. Para 6, specific stated after service notice,
You are
whereas
accused
the
number 6.
accused number 6.
You are the accused number 6.
Yes.
And we are the
Then?
No, we are,
number 5.
we are the accused number 5, but accused number 6, no notice is served.
Number
So
50,
he'll
chairman.
come,
He's the accused number 6 is the chairman.
Will defend his own case, but now come to your case, you have received the notice. Proper notice is served on you.
The proper notice
This is
served.
not a case that is notice, you have not received the notice. It's a petitioner number 6 will come later on. But at present, everything is clear, notice is served on you regarding the transfer of and everything, new amendment as per you never not so aware about, but
Yes.
anyway, new amendment. That for the new amendment only the case has been transferred to Guwahati at present, now case is proceeding.
Yes, yes.
Now, whatever the earlier part was there in regards to suppose the transfer of case, filing of the case, reviving of the case, these are not in existence at present.
At
Because
present.
it has been, directed.
But
the
one thing is that,
was
my lord,
directed
one
to
thing is
file
that,
a
my lord.
fresh case with, in a proper forum.
No.
So in pursuant to that order, he approached this Guwahati court and then the case is now proceeded.
Yes.
Now the question is that you are saying the director is not made the party
Yes.
and without making him party, you are the party. So who are you?
No, no,
now?
director is not a made party. Director is a made party, but no specific allegation, affirmation has been made in the complaint petition against the director.
I'm the director.
Against the
Director.
Who are you?
I'm the director.
You
I'm the
are-
director.
You are the director.
I am
So
director.
you are saying that no specific allegation.
Allegation against me.
So being the director, you, vicarious liability is exist on you also. I
Yes, yes, vicarious liability, that is judgment is there, my lord. So many judgment is
then
there. The
The
specific
checks
allegation.
were issued by whom?
Check issued by that representative of the company.
Representative of the company. So
Accused
you being
number
the
2 and 3.
director, are you not?
Accused number 2 and 3 has issued the check.
You being the director, are you? not-
I'm, how can I know the day-to-day affairs? I'm not looking after day-to-day affairs
Oh.
of the company.
How can you say that? How can you say that? Being the director, how can you say
It's
that?
a
I'm
big
not,
co-
I'm
it's a
not
big
aware of
company.
about
How can I
day-to-day
come to know that
affairs
what,
of the
how the,
company.
chair?
Whether you can say that. Cannot say, you are being the director, you should know what is going on in your company.
Man, there are so many
And
judgment, my lord. I
five
just read
checks-
out.
Five checks has been already been issued. No,
But-
judgment will come later on.
Ah.
The merit of the case, when it will be heard on the merit of case, that will come later on. But the
Yeah.
question is that The being director, it's not a case that there has to be any specific allegation against you. Being the director, it has to be, you have to be made a party here. That is the case. Now at present, these things, see, it is the motion stage. I have already spent more than, most really 25.
So, my lord, my submission is that, my lord,
I
let the
cannot
record be
spend
called.
more time, but the question is that, how many, the respondents are there?
Respondent. Respondent, how many respondent?
One.
One.
Zero, sir.
One state, two respondent. In my petition, there are two
State is the
respondent.
formal party and the one,
Yes.
Arihan International.
Yes, I didn't. He's a complainant.
So basically now we have challenged the order of cognizance, and what you have put to challenge here?
And my lord, what happened? Another particularly very important thing, when the person who has given the initial deposition, he should be authorized. But in my case, he has no authorized to represent the company, Arihan International. I've stated this also. So let my record become, my case is that let the case record become, you will lordship go through it. In the meantime, the proceeding may be stayed for the time being. Initial proceeding till returnable of the case record. Till return of case, because there's so many lacunae there. How he's filling up, I don't know, because court is taking so many cognizance. 3 times cognizance is it any when criminal case 3 times cognizance can be taken?
So basically, what is the order you have put to challenge here?
Is
What is
1811.
the order? 1811.
Yes, my lord.
By 1811.
This is
this is
first
first
initial,
taken.
first cognizance.
First cognizance means
1811.
cognizance by this court of JMFC Kamrup.
Kamrup.
No, no, he has also challenged 2019.
Hmm?
2019.
At 29, if my prayer, if you also go through the prayer.
So as there are how many accused persons are there? So you are only 2 here.
No, two.
Huh?
There are total 6 accused persons. We are number 5.
We are 3, we are the 6 accused person.
We are the accused.
You may be 6 accused. How many before this 4?
Before the accused number, so
1 and 2.
1 and 5.
We are the accused.
We are 1, I'm the 1 of the 5, I'm the 5.
And the accused number 5.
I'm the accused number 5. Complaint petition, go through the complaint petition. Page 49. There are 6 accused. 1, 2, 3, 4, 5.
In this current petition.
But in my current petition,
we filed by one.
the company, and second is the accused number 5. That means the son of Sitane Nama, director, Madhukan Project Limited, director.
Mr. SP to the land council for the petition. And that's the kind of and it's notification. And 28 BNSS for watching proceeding of CR. Case number 449 and pending before the court plan GMFC number 2 Kamrup end. And also challenge the order of taking cognizance by the learned court of GMFC. Right, order dated 11. Issue notice to the respondents, no formal notice required to serve the statement. However, copy of the petition may be served during the course of the next time also called for the scan. Mr. Mitra has submitted that the present there is no specific allegation brought against the present petition number 2, and petition number 1 is the appeal. He was also not aware about the issue that is to the respondent, and further it submitted that there are several legal infirmities in the entire process of filing the case report, transfer of the case vis-a-vis the order of taking cognizance. Mr. Mitra further submitted that while taking cognizance of the case, the statement of one person is recorded in section 200 and 202 CRPC, who were not the authorized person of the respondent number 2, and without making any inquiry, the order of providence was passed on the basis of the statement made by an unauthorized person. Apart from that, he also brought several raised several legal points in the present case. Considering the submission made by Mr. Mehta on the case, that the further proceeding against petitioner, both the petition number 1 and 2, further proceeding in case number 2 and so only in respect of petition number 1 and 2, we state illegal. This is matter according now. To take steps for the respondent, we are listing it after 4 weeks, and against 1 and 2, that is the petitioners, the stay will be operated. Stay will be operated.
1 and 2.
Who is here? There are 1 and 2 only.
This is a crossing application, except for the abatement of suicide. And we are challenging the charge sheet and the proceeding pending before the learned session judge. So in this case, what happened? My wife, she has committed suicide, and Lordship immediately the sister. page number 18.
Your wife committed suicide.
Yes, Lordship.
So
Lordship,
you are the
kindly-
prime accused. You are
Husband,
you are
husband,
considered
yes,
the
yes,
husband
yes,
or the
yes.
prime
Husband has been made accused. And the thing is that no ingredients of 108, which is necessary,
Hmm.
has not been incorporated, and nothing has been found. Lordship. Just I'm submitting that one judgment also been placing, Lordship.
No, that will be
Yes,
let
Lord.
down.
Facts I'm coming to part. Facts I'm coming to the part one by one, Lordship. Very important. So FIR is lodged first. You only page to come page number 18. FIR is lodged by the sister.
Sister
On one, yes,
deceased.
sister of the deceased wife. Sister-in-law. So she lodged that. With due respect, I would like to inform you that sister Pallavi Gogoi was married to Swapan Kumar Borgohain. So in the year 2000, after marriage, child named so-and-so Loy was born, who is about 2.5, 6. Following marriage, there were personal disputes with the husband and wife. We had advised both of them live peacefully with each other. On 1/11/2000 at around 8:30 am, her husband Swapan Kumar Borgohain came to her parental house and informed us that they had been living argument with since 30/11/2024. Then today, 1/11/2024 at about 11:30 am, my sister along with her son jumped off Dikho bridge and committed suicide due to mental harassment from his husband. It is learned that so. So husband is informed to that. Immediately or next day, he was arrested. Then Lordship come to page number 25. And see. Just after 15 or 60 days, he was granted bail. No material was found. But this is page number 25. Learned counsel petition is present. CD is called for by the order data so. The Pritish Gohai has filed a petition so. Accused Swapan Kumar Gohai has been detained in judicial custody. In this case, the instant Ejahar has been lodged by one Smrita Gogoi so before the Najara police station, and in said Ejahar informed alleged that her sister Pallavi Gogoi was married to the accused Swapan Kumar Borgohain 2021. Another wedlock, they have son 2.5 years. It is alleged that informant Pallavi Gogoi used to tell informant about argument with her husband, which he advised them to live peacefully. It is alleged that on so at the accused Kumar went to the veteran house, informed that he has been fighting with his Pallavi Gogoi. So it is also argued that on 1/2/35 at about 11:30, it should be AM, actually AM. The informant said Pallavi Gogoi with her son jumped into the Dikhon bridge, so. The next, page 26. I have perused the CD and considered the bail objection submitted by IO. I have also perused the materials collected by IO during the course of the investigation and statement of witness so far recorded IO case along with the suicide note, which has been seized by the instant by IO. Considering the nature of the offense, the material collected so far, including the progress of the investigation so far, also the fact the accused is in jail has since 2/11, I am of the opinion releasing the accused on bail at the stage of not hamper the allegation. So after 15 days, he was granted bail. Then you know, come to the page number 26, the suicide note also. If you have permit to read out in Assamese, I can read out it more clearly, it will come up. 3 বছৰ অকল মোৰ মা আৰু ভাইটিৰ কথা ভাবিয়ে জীয়াই আছিলো। বহুত দুখ পাব বা মা ভাইটি বা হাতে কিমান চিন্তা আছিল সিহঁতৰ, মোৰ ভাইটি চাগে কান্দি কান্দি পগলা হৈ যাব। মাৰ এইটো বয়সত কিয় হ'ব ভাবিলেই মই কষ্ট পাইছো, কিন্তু মা এই একদম অসহায় হৈ গ'লে একদম মজবুত কাম নকৰা হৈ গৈছে মৃত্যুৰ বাহিৰে একো ৰাস্তাই দেখা নাই মোক আশীৰ্বাদ কৰিব মা মই যাতে আকৌ লয়ৰ লগত মুখত থাকিব পাৰো তহঁতি মোক পাহৰি নাযাবি লৈকে পাহৰি নাযাবি এতিয়া সপনক কওঁ মই মৰি যাম বুলি তেতিয়া মোক কয় ঘৰত গৈ মৰগে যা তাৰ একো বেয়া নেলাগে সি সদায় বিচাৰে মই মৰি যোৱাটো তাৰ কাৰণে মৰি দিছো মই যাতে শান্তি হৈ আমি মৰাৰ লগে লগে ভাইটি তই চিন্তা নকৰিবি নিজৰ কামবোৰ ভালকৈ কৰিবি বিয়াখন তাইৰ লগতে ছোৱালীৰ নামটো পঞ্চুৰিকা ভালকৈ পাতিবি তাই মোৰ কথাবোৰ কবি তহঁতৰ লগত মই সদায় আছো মোৰ লগত তহঁতি কেতিয়াও নেপাহৰিবি তহঁতক বহুত মিছ কৰিম তহঁতৰ ইমান বহুত প্লানিং আছিলে ভালকৈ বিয়া পাতিবি মই আৰু লয় থাকিম একদম মৰিবলৈ মন নাই কিন্তু মোৰ উপায় নাই তহঁতি একো পুলিচক কেছ নিদিবি ইহঁতি নিজে ঘৰৰ ভিতৰত পাব ভগৱানে আৰু মোৰ বিশ্বাস আছে ঘৰত কিবা এটা হলে অকল মোৰ মাৰলৈ ফোন লগাব মোৰ বা হতক কমপ্লেইন দিয়ে মোৰ ককায়েকক তপনক ৱাইফক কোনোবাই বিয়া কৰিলেই মোক সি গালি দিয়াই সেইকাৰণে মাকতে কাশ্মীৰ লৈ ভয় কৰে তাইৰ কাৰণে বেলেগে ৰোল বনাই দিয়ে যেনেকে পিৰিয়ড হলে টেবুলত বহি খাবলৈ দিয়ে আৰু মই তলত বহো খাওঁ পিতাই নিজে মোক আনি দিয়ে মোক 3 বছৰ ভালকৈ চিনি পালো সিহঁতক মাকে কেতিয়াও নেভাবিলে যে সপনৰ সংসাৰখন ভালকে থাকক সদায় কথাই লগে মোৰ ঘৰলৈ গলে মানুহবোৰক কি কৈ নাহে ইহঁতি নাহিলে ভাল পাওঁ কোনজনী মানুহ শাহুৰেকে এনেকৈ বোৱাৰীজনী ঘৰলৈ গলে নাহিবলৈ কয় গোটেই সংসাৰখন ভাবি চল তেওঁ ভালকৈ মাছেদি ভাত কেইটা খাবলৈ পালে হ'ল বাকী পলৈ মৰি যাওক লয় মৰি যাওক এইবোৰ কথা দৰকাৰী নাই সকলো মানুহজনে ভাৰতী বৰগোহাঁই কিমান অহংকাৰী মানুহক মই বেলেগকৈ নকলেও হ'ব ঢেৰ দুখ পাবলগীয়া আৰু সেইবোৰ চব পাহৰি মৃত্যু হ'ব পুতেকৰ লগত কৰিবলৈ গৈ তেওঁ মুখখন ফুলাই থাকিব পুতেকে মোক বেছিকৈ মাতিলেও বেয়া নাই পায় বাকী কেইটা পুতেকৰ লগত এইবোৰ কৰিব নোৱাৰে অকল সপনৰ লগত কৰে তেওঁ এনেকুৱা এতিয়া আকৌ বিয়া পতাই দিব লগা চাব আপোনালোকে মই পাগলী আদিলো কি বুলি কব মানুহক মই বিচাৰো সপনক একো নহওক এনেকৈ মুকলি আকাশত থাকক তাক কোনো একো শাস্তি দিব নেলাগে বিশেষকৈ চাকৰিটো গুচি গলে তাৰ বহুত দিগদাৰ হ'ব কি এনেকৈ মোৰ লগত এই অকলে বহুত কষ্ট পালে বুজাব নোৱাৰো এইবোৰ কথা অকল মোৰ মানুহটোৱে বুজি পালে ভগৱানক বহুত ধন্যবাদ মোক উলাৰটো দিয়াৰ বাবে কিন্তু আমাৰ দুটাক যেন তুমি এতিয়াও হাতত তুলি লোৱা এইবোৰ আঁকি মোক অকল মানসিক শাস্তি লাগে বাকি একো নালাগে so these are emotional part is written in very well now come to the thing is that on 11:30 when only the mother-in-law was in the home she left the house along with 8:30 the petitioner informed to that she has fight with me nobody bothered nothing has come and nobody knows because 108 has come up that's why I'm placing the judgment and lordship I will read out all the things the direct nexus has to be think in that here what has happened প্ৰতিটো বস্তু emotionally is going on শাস্তি পাব নালাগে চাকৰি যাব এইটো হ'ব কোনো কথা নাই মই ইমান ঠিক থাকো so if she has means there is no question of torture but what she is expecting she made real something whatever that was come up and on the day fateful day even also she Hajikasi Afghan went out along with her soul and that has also been noticed by the sister also said that and the mother-in-law also said that when you come to page number 40 court has that's why after 1560 court has granted bail then page number come to page number 40 the sister who lost FIR what he said well for torturing dowry anything such as
Hearing the matter finally, I think.
so my only submission before this right now before this submission not my only submission before this court let the record call for before this court
What is the stage of the case at present?
because court has framed the charge and I am the assistant engineer
What
in
is the
assistance
next date?
engineer in
Next
senior
one?
assistant engineer in ONGC
Next day is fixed on.
lordship
Next.
that I have to ask that I have not
Trial is not
so
yet commenced.
after yes I will just after at 2 I will inform that part also with the honorable court next day
See, this kind of case, we cannot stay the proceeding.
no lordship
At present, we
now
cannot
why are we
stay the
coming to that why am coming to that decision no because the trial will go on the statement recorded by I have annexed that all the records kindly before this honorable I have record if not find anything material, I am not saying that the process to dismiss the reject the case. For time being, record should come for.
Firstly, I want to go to the FIR, Lordship. Here clearly it is stated that he went to the husband went to the house of her parental house, Lordship, and he has complained. And after on the same day, Lordship, that is on 1/11/2024 at 8:30, and it is on 11:30, he committed suicide. Firstly, Lordship, proximity is there. It is not that proximity is not there. And my friend has very cleverly, Lordship, has not read the material part where it is, Lordship. It is on 28, page 28 in the English part, Lordship. 28. From the last second para, Lordship. May I read, Lordship? The happiest person after hearing this news is Sopan Kumar Borgohain. It has been 3 years since the marriage, but only harassment is given. He has beaten me on 2 occasions, and one day he grabbed my neck. He has not read it, Lordship. So there is definitely materials are there, Lordship. It is not that primarily it is there, Lordship.
I am submitting.
One sentence is there in this your suicide note.
Lordship.
যে তই মৰি গলে ভাল পাওঁ, তই ঘৰত গৈ মৰ।
Lordship, yes.
This kind of insistence is there.
Lordship, it is
What is the other part of the case?
Yes, Lordship,
So I don't think it is the case.
Lordship,
of
I
A at
also know,
present.
Lordship.
Let the case record be come
Lordship.
forward, and charge has already been framed. Most probably your when the charge was framed, can you tell us?
That is Lordship, that
Charges framed on Lordship.
last order, Lordship, that is page number 45.
45.
18/7/2025.
2025.
Or fixing 11/9, Lordship. 11/9.
For
Next
evidence.
date is 11/9, sorry.
For evidence.
11
Yes, page number 45, kindly. Annexure 10, Lordship. The Lordship, after call for the record, go through the part, find everything material.
11/9 is for
Otherwise,
evidence.
yes, 11/9.
Okay,
So,
prior to 11/9, it may not be possible for keeping any.
no, even,
you
so
can
that's
take
why,
any
Lordship, stay that.
adjournment on that day also.
Yes,
we
stay
may
that
take-
proceeding, that is only, sir, with that.
Let's Mita Gogoi is also appeared. We are listing it out. Third, Mr. P. Sharma, Ilanet Consequently. Third. Mr. Adam Dust, Ilanet, he appearing on the state. Issue notice corridor. আৰু call for the scan copy of the TC. No formal notices. Also call for the scan copy of the TC. If the better be accordingly listed. We'll try to accommodate you before Bihu, because one date definitely it will go 11/9. Somehow we can be managed. And then can be, I think, on either 23 or 24. 23rd of September, realistic.
23rd of
September.
3rd
This month.
September. Yes,
To
Lordship, no,
take
sir.
steps, and she is a resident of Sibsagar.
Yes, sir. Najira,
If she
actually.
doesn't appear also, matter maybe.
This is Najira, but Lordship, that's
Najira, no.
address is here. Most of it is Najira, actually, resident of Najira.
Take steps by today or by tomorrow itself.
Yes.
We'll switch it, even if it doesn't come there, then we'll hear the other side. I mean, the state will be heard.
Still, yes, it's only stays to be granted or till that, let the record come, because I am not objecting. If any incriminating material finds, that's why Lordship, the Honorable Ujjwal Bhai's judgment, elaborately, everything is included.
I know.
Any
Because
single thing is
there
found.
are-
Yes,
there are
this is
many
the,
factors.
kindly Lordship, in this case, I see, after 16 days, he was granted bail. If there will definitely, if there would have been any incriminating material, because every emotion comes up only. Suppose the demand of dowry was made 3 years back, so many
For a
things.
lady with
That is
with
only.
his own child, she
Yeah, that is also painful. That is also painful. Because I have informed.
Happily, she had did
Yes,
not
yes,
complain.
that is only that. Because emotion, because I intimated to the sister, this has happened. Nobody has come up. So only that part, till that, that stay should be there. And after,
23/9 realistic.
yes, I will take steps tomorrow. That's it. I will take steps. Yes. One number to this. 86338006011. You know, take it.
It's 23rd of
I stay. Okay, obliged.
See, there are many matters have been linked, but at 2, we have a VC from Itanagar. And the hearing will be there. 2 matters are there, one bail matter. Bail matter may not take such time, but it's the cancellation of bail regarding, so it may take some time. And thereafter, one election matter is there. Mr. T. Mujumdar is going to appear. So if time permits, then definitely will be here. It's not a case. Otherwise, I don't know. May. And if the election matter doesn't take much time, then definitely it will time. The one bail hearing matter is also there. It was scan copy we have received. We're supposed to take the hearing matter, but it will not be proper because you have already scan copy you have received. Yeah.
Item number 23.
Yes, 23 is the Mr.
Yes, sir. My lord, here, what has happened last occasion, my lord, some 161 statements were called for, my lord. That has been received today. It's a little bulky one, my lord. I need some time to go through it, my lord. So matter may be fixed day after tomorrow or anything. Let it be Friday, I'm not sure.
Friday.
Friday.
Friday. Okay, then it will be.
Item number 23.
You just go through it because 161 was not available on.
Yes, yes, sir.
And that is a specific case, Lord.
Yes,
Pardon?
That is my specific case, Lord.
Yes. Yes. Then we are listing it on day after tomorrow.
My lord,
Day after
yes.
tomorrow. Fifth. Last time. 5-9 we are listing it on.
Yes, sir.
My lord, may I pray next admission item, my lord, 12 to 17.
These are all connected matter, I think, na?
My lord.
Yes, my lord, connected matter.
12 to 17. Yeah, all the transfer matters are there.
My lord.
No, we are here to hear the matter. I am here to hear the matter, but I don't know the time.
My lord, there's
whether-
my lord, very fixed, my lord, the petitioner, you know. Well,
You are appearing in all the.
I'm from the respondent.
For the respondents.
Let me fix your lordship.
Sort that, my lord.
But at this stage, I'm not in a position how much money, I mean, time, I don't know, the time will be taken, may be taken by this election matter. The
Hello.
bail matter will not take much time, maybe, but the election matter may take some time. So
My
that's why I'm
lord.
just saying, it's not a case that if time permits, then definitely I'm here to say.
My lord, then.
Or otherwise, if you want any date, then 12 to 17, na?
Yes, sir.
It can be otherwise. Both the parties are here only. You are for the respondent
I'm from the respondent number, item number
in item number
16, 17, my lord, finished for other.
12, 13 and
16, 17.
Only
You are
the-
for the 12?
12, 13 and 14.
Your
I-
lordship, for item number 12, your lordship, item number 12, your lordship, the service not yet complete, your lordship.
Completed.
For the sole respondent, your lordship. For item number 12, your lordship, the service not yet complete, your lordship.
Not complete.
Not your lordship. That your
In
lordship.
item number 12.
12, your
12.
lordship. The service.
Oh, okay, so that's for the name of the respondent, but
Item-
parties are almost same. Then why the
Only our,
Item number 12, the respondent name is different, your lordship. Other respondents, they are appearing, your lordship.
my lord, our prayer is, my lord, it will be segregated because they are enjoying the same at the last 2 years.
It is.
And they have not able to sub copy order to the
so
item
have
number
you
12.
gone through the order of the office note?
Yes, your lordship.
What it says?
5/8/25, your lordship, answer notice is not yet received, your lordship. The service notice is not yet received, your lordship.
The address is proper otherwise?
Yes, your lordship, address is proper, your lordship. We have served the notice, your lordship. But till date, it has not been received, your lordship.
Then if it is have to be abated because Mr. saying that if you are, I mean, enjoying this,
Stay, my lord,
yes,
last 2 years.
then so definitely.
Your lordship.
They have technically take up the matter, my lord, that one keeping pending, my lord.
Let me fix, your lordship. as well.
We segregated, my lord, that other
Average
matter.
service report, your
If
lordship.
these other 4 matters, my lord, any, my lord, favorable order is, my lord,
It is
and
arising
it
from
will
the
take
same-
effect, my lord.
That is 13 to 17 maybe
My lord, my lord.
will do.
Your lordship,
Yes, then
it is arising from the same contract, your lordship. From a single contract, all these payment
Yes,
has
yes.
been made, your lordship. If it's aggregated, your lordship, only this will be left out, your lordship.
Not single
Not
contract, my
single.
lord, different person, different contract, but petitioner is the same person who has the, my lord, failed to pay the other persons, my lord, the respondents. That is not the same transaction.
Or your lordship,
We
will
just
take
see
step-
the 12, item number 12 is that.
or your lordship, will take fresh steps, your lordship, for respondent number, for this item number 12, your lordship.
Otherwise, you may be directed to take fresh steps.
Yes, your lordship, we take fresh step for respondent for this item number 12, your lordship.
Item
And then
number 12.
after 1 week, a date may be fixed, your lordship, or the matter to be taken up together, then your lordship. If this not is received again, your lordship, then the matter will be segregated, your lordship, as your lordship may please.
Now, after 1 week, your report will
Not-
complete that it won't come, I think. At least minimum 2 weeks will be required.
2 weeks, then your lordship may be, after 2 weeks, a date may be given, your lordship.
You want a fixed date here?
No.
Or after 2?
After 2 weeks, your
After
lordship.
2.
Yes, your lordship.
বাকি তাতে একে মানুহ করণীয় আছে Sasrani is appearing on 1670 that you are also Q Laskar is also appearing Q Laskar and mainly Q Laskar is appearing 12 13 13 14 15 and Mr. Sarania is appearing on 16 and 17
16.
and S Nazdin is appearing on for all the petition. At 12 port item number in criminal petition number EW 2024, it is submitted by MS Nazdin that the notice on the respondent, sole respondent is not yet returned. And as part of this note dated 5/8/2025 also, it reveals that the AD, neither the AD nor the answer notice in respect of the respondent is received by the concerned section. In view of this, petitioner is hereby directed to take fresh steps in connection with the transfer petition criminal number 8/2020 to register 18 as list all the matters after 2 weeks as on a date fixed by the registry.
Your lordship, interim
In
order.
all the matters,
Interim
previous
orders,
date,
yes, sir.
then be continued with next. Otherwise, if same thing is there, Mr. Swaranya, then
No.
we will try to segregate the matter.
That may be observed, my lord, if it is, my lord, not served
This
in the
part is
next date, it
submitted
will
by
be
Mr.
segregated.
Saranya that due to the pendency of due to non-service of notice on the respondent in connection with transfer petition number 8 of this. So the other matters are also been pending. To keep rate to segregate the other matters and the list. We'll see.
My lord.
My lord, item number 18, man, small criminal appeal, my lord. Prayer for suspension of sentence is also there.
No, we are not saying that we are not going to take the matters. We are simply saying that if time permits, we'll take up. If time doesn't permit, it may not take up. That's all.
Okay, fine. I'm here.
My lord,
Yes, this is for you are appealing for this bail matter.
yes, my lord, bail matter. I filed my Wakalanama with an implement application today to allow me to take part in the proceeding. I'm the son of the deceased, and I'm the one who filed criminal petition to set aside the bail.
Earlier, you filed one criminal petition for setting aside the bail that was
Yes,
allowed.
yes, my lord, my lord. That was allowed by your lordship. Now they have filed this ABA, and if your lordship permits me, I'll take in the proceeding. I'll not overtake PP. I'll just follow PP, and I'll just submit some more from my point also. But I'll not try to supersede public prosecutor. That's my humble submission, my lord. I'll abide by the law.
Yes, Mr. Talo, what do you want to say?
Yes, that can be done. He can appear, but with a permission from PP, not
Yes, to assist. But in that case,
assist
have you
the-
filed any interlocutory application for your implement or verbally
Yes.
you have submitted?
No, I have filed today. I have
Today?
filed my work. I have filed.
Oh.
I'll try to assist the PP, and if your lordship permits me, in case 1 or 2 points, I have filed today out there in Itanagar. Today only, my lord.
We have not received the copy, I think, I'm concerning.
They are already in last time also they appeared, my lord.
Appeared.
So their presence can be recorded, my lord. Their presence can be recorded, my lord. There's the formal implement may not be required, my lord. They may participate, my lord. But otherwise, my lord, is formal
Yes, that's what
implement.
I'm
It will
saying.
take unnecessary time, my lord. My lord.
Yes, if he has already filed his Bakaratnama, he may be heard or he may be given an opportunity of being heard. But there may not be any such formal order.
My
So
lord,
now today you are in a position to submit in that figure. Then we are going to hear. Mr. Talu is also there. You may assist him also.
then, my lord, I'll simply submit or assist after Mr. Tado gives his submission.
Yes, by today itself you can submit.
Uh,
Or you need time because he is in custody. The person is in custody.
Yes, the person is custody. I also understand that. That's why the other day I made a special request because my mom's surgery is on Saturday.
Yes.
Because therefore I have to come down to Imphal to arrange for the Shraddha ceremony. That is only my difficulty. Therefore, I humbly requested
On the last day your prayer was considered regarding your mother's Shraddha ceremony was there. I can still remember. So it was considered. But today, if you are ready, then we may hear the matter because
my lord, my humble submission would be, if your lordship permits me, I can submit my addition, if anything to submit on 8. Or may not be necessary also after hearing the PP submission,
lord,
it would be necessary also.
It would be based on the TCR only. Trial court record has been already called for, my lord. The
Yes,
PPs,
it has been
addition is done, my lord. It is there, my lord. It can be done today itself, my lord.
My lord, I'm also aware of the facts. I'm also quite aware of the facts.
you are saying, Mr. Talu, my Tagum today itself, you are saying?
Yes, my lord, it
Yes,
can be
it
done.
can be, it can be, it can.
Yes,
Because the copy is also with us.
Yes, your lordship, TCR is not available here.
It's already through registry only. It was called, my lord.
What is
This is a court-to-court communication. It should be before the honorable this court.
It is already forwarded to the through registry, my lord. It's already in the case.
But we have also have a right to peruse the record. At what stage is it pending and what has?
No, matter was fixed today. You have not perused the record.
Last time
You
I
have
was
not
not there,
perused the
but
record, Mr. Talu.
no, I have not yet perused.
Then again, it will be a problem.
So then we can dispose of this IA,
my lord,
for implement. We will
in
dispose
my
of
respectful submission, my lord, even formal implement not be required in case of bail hearing. Since they are present, even the proceeding also they participated. We have no objection their participation, my lord, because they cannot go beyond that. What is TCR, my lord? TCR already been called for, my lord. That's why my respectful submission, my lord.
No, the question is, it is okay. He may not be implemented as a formal party or implement order may not be there, but he is at liberty. He can submit. That's okay. Now, whether additional PP is prepared, Mr. Whether you are prepared or not.
Yes,
Because it's record with us. Yes.
As per petition and documents enclosed herewith, I can submit, but there is something to peruse in the TCR. At what stage and what actually is now going on in the trial court?
Most probably it is in the stage of evidence, I think. Because prior to the order of bail also, the evidence was recorded. Now, three PWs were recorded. Now, at least, maybe at the stage of evidence, I think.
Now, maybe, yes, of course, it is in evidence stage, but it may be in the final stage also. If there is a condition like that, final
So
there
you
is
want
likely to be,
status report, present status report of the case, you want?
yes, exactly.
My
Well,
lord,
from my
because-
knowledge
my lord-
goes, so from my knowledge goes, I think already 14 PWs have been examined, they have met their deposition, and the matter subject to hearing is fixed on 14/9 of this month, and it's like almost at the end of the trial. Thereafter, 313 will be done after 2 dates. And if at all they want to enter defense, they will.
So at present, 14 numbers of witnesses has been examined, and how many remaining, can you tell us any number remaining? witnesses?
Maybe another 2, 3. Maybe there is no much. Slightly because the matter is on 14 also. I think 4 witnesses, another IO, only 3 or 4 maybe. Because the seizure witness and the IOs are left to be examined. The seizure witness, who were the seizure witness of the CCTV footage and the IO.
My lord, in my respectful submission, my lord, earlier when we moved this bail application, altogether 14 prosecution witness was examined and discharged by the trial court. Thereafter, my lord, after filing this bail application, my lord, further 2 more witnesses were examined, my lord, including IO of the case, my lord. That been done on 30 July 2025, my lord. So as of now, my lord, hardly 3 official witnesses remain, man. That is 2 of the my lord, the SP and OC, my lord, officer in charge and of E0 police station, and the DSP, my lord, of higher ranking, my lord, the official witness, my lord. So far, my lord, the eyewitness part is there's no any eyewitness, anything remain as of now, my lord. What they projected it to be eyewitness that has been examined, and even that Learned Trial Court, while rejecting the bail application, they have reflected, my lord. Even there's no any incriminating statement given by those which is stated to be eyewitness, my lord. That everything that was projected earlier that has been turned out as of now changed, my lord. There's no any incriminating material against the alleged accused, my lord. So since the all material witness has been examined, my lord, only but the remaining part is only official witness, my lord, and there's no any chance of influencing or tampering with the evidence, my lord. All the official witness, my lord. The alleged accused person, my lord, he was a retired constable, my lord. And so far, official witness is a higher ranking officer of the inspector up to the level of DSP, my lord. So there's no chance of any influencing also, my lord. Since there's no any eyewitness, my lord.
So
Matter of fact,
can
my
we
lord,
hear the matter, or what? Are you, PP, you're ready?
Your Lordship,
Part her matter may not be.
this is my learned friend's submission that so far it is already put to record. If there is almost done, then it is a verge of conclusion of trial. Only 313 left. Then this is serious offense 302.
that is all right, madam. Even my lord was just because bail application cannot be keep pending for the long period, my lord. Either reject it if there's any material, my lord may
Okay,
reject it, my lord. That is-
Okay, start.
my lord, that is where, my lord. In my respectful submission, as it has already been highlighted, my lord, an earlier occasion when the earlier alleged accused person was enlarged on bail by the trial court, my lord, and that was put to challenge by the complainant, my lord, by filing criminal petition number 97 of 2024, my lord. And, my lord, the criminal petition, my lord, was allowed, and the bail granted by the trial court was rejected, my lord. The order earlier judgment and order that passed by this honorable court, my lord, in the criminal petition number 97 of 2024, my lord, is at page 26 to 48, my lord. 48, my lord, finding of the my lord is page 48, my lord. Will see the finding, last finding, 48, my lord. It start from page 26. My lord, primary, my lord, was of opinion that since as projected by the complaint petitioner, my lord, in the case, my lord, there's some eyewitness to be examined, my lord. So, and the main, my lord, ground for releasing alleged accused person on bail by the trial court was on basically on the age factor, saying that since the alleged accused person is of age of 72 years, on that account, my lord, since only on the account of the age factor, this could not have, the bail could not have been granted. Other factors should also have been considered, including the possibilities of influencing eyewitness and all, my lord. Now, on that account, my lord has cancelled the bail order by the order dated 13 June 2025, my lord, wherein, my lord, after cancelling, my lord, it was directed that alleged accused to appear before the learned trial court and to file a fresh application. And upon filing of the fresh application, it was liberty was granted to the trial court to consider the matter afresh, my lord. So accordingly, my lord, in terms of the direction of this honorable court, on 17 June 2025, my lord, at page 49.
17th of June.
Yes, 17, my lord. 17 June, my lord. Page 49, my lord. The alleged accused surrendered before the trial court, my lord. Accordingly, he was taken into custody. He has been taken into custody on same day, my lord. Thereafter, my lord, at page 50, my lord, we filed a bail application for consideration of his bail application on fresh, my lord. Page 50, my lord. It is started from page 50 to 54, my lord. So here, my lord, entire observation, my lord, it is entire observation, my lord, it is rather in my favor, my lord. There's no any incriminating material evidence so far adduced, my lord. As on time of the consideration of bail application, 26 June 2025, my lord, altogether 14 witnesses were examined, my lord, including
1-4,
my lord.
Yes.
1-4 witnesses were examined, age on date 26 June 2025, my lord, including 2 witnesses, my lord, which they stated to be a eyewitness, my lord, that were also examined, and the learned trial court has also taken into record that those eyewitnesses stated that the PW1 and 3, which they stated to be eyewitness, my lord, there was no any adverse evidence against the alleged accused person when they were called for deposing their witness, my lord. They were at the time adducing the witness, my lord, evidence, my lord. So, but only despite of this whole thing, my lord, only the learned trial court has noted that there's no any change of circumstances, my lord. That's only on basically on this ground, my lord, bail application filed by the alleged accused person was rejected, my lord. Although there's no any incriminating material, there's no any adverse finding, my lord, only on that ground. My lord, so far the change of circumstances is concerned, my lord. Earlier time, my lord, when the first bail was cancelled by this honorable court, my lord, on the ground that the trial court had not considered the material fact, my lord. Only on age factor he has been enlarged. Therefore, it was directed to consider afresh, my lord. Because at the time of filing criminal petition, only 3 witnesses were examined. Now, as of now, when we filed 14 eyewitnesses have been examined, but there's substantial change of witnesses circumstances there, my lord, and there's no material evidence against any adverse against the alleged accused person, my lord. Therefore, in my respectful submission, my lord, as of now, my lord, the 17 witness has been examined, official witness, my lord. List of witnesses, my lord, I've annexed at page 56, my lord. This page 56, my lord, this is the list of witnesses, my lord. The annexed in the charge sheet, my lord, I've extracted a copy I've annexed here with page 56 type copy, my lord. Up to 16, my lord. 14, my lord, it was already examined at the time of bail hearing. And 15, 16, it was examined on 30 July 2025 during the pendency of this application, my lord. Now remaining, my lord, 3 official witnesses there, my lord. And since they are not eyewitness also, and they are higher ranking officer, my lord, there's no chance of tampering or influencing, but even they are not directly, my lord, the eyewitness, my lord. So in my respectful submission, my lord, my lord, when there's no any material evidence is forthcoming against the accused person, my lord, in respectful submission, he's deserved to be enlarged on bail, my lord, because the unless, my lord, there's any evidence, my lord, and there's any adverse against the petition, alleged accused person, my lord, there's no use, my lord. Ultimately, my lord, the human right, the innocency, principle of innocency, my lord, has to be considered. It's a paramount, my lord. My lord, in this case, my lord, and to sum up, my lord, just I supplied, my lord, the 2 citation, my lord, in earlier occasion, my lord. I believe it must be there, my lord, on the record, my lord. Just I'll rely to my citation, my 2 judgment I relied, my lord. Compilation I've submitted, my lord.
Yes. These
Yes,
are-
my lord. Yes, my lord. My lord, I just in compilation, my
One
lord,
is
page.
2012, one SCC.
Yes, my lord. The relevant page, my lord, page 13, 14, my lord, of this first judgment, my lord.
You are
I'll just,
relying para, which para?
my lord, para 21. Just I'll not read out, my lord. I'll just mark it. Para 21, 22, 23, and 27, page 14, my lord. And thereafter, my lord, second, my lord, this I just highlighted, I'll just mark it, my lord. It is settled proposition of law, my lord. My lord, next judgment, my lord, 2024 SSC online, my lord. Page 54, my lord. My lord, this is start from page 27. This is decided recently only, my lord, 2025 decision only, my lord. The judgment was authored by the 2 bench, my lord, consisting of Justice Suryakant and Ujjal were in separate seat. Although the final, my lord, finding is same, but the judgment has been authored separately, and I'm relying the judgment of the Justice Ujjal Bhuya, my lord, page 54 in compilation, my lord. Page 54. Page 54, para 38, 39, 40, my lord. This is, my lord, based on page 54, my lord, of Kejriwal's, my lord, a compilation. My lord, got it, my lord.
Yes.
Yes, my lord. This relevant page, my lord, para, page 54.
This is Ujjal Bhuya, yes.
Para 38, 39, 40, my lord. It's also based on, my lord, even whatever, my lord, maybe, my lord, that's this, the bail is a part of human right, my lord. So unless, because in so far, my lord, all substantial evidence we have seen, my lord, adduced, my lord. This is my lord, remaining is nothing, my lord. Only official witnesses, my lord, and other all the material witness that have been examined, and there's no material evidence against the alleged accused person, my lord. This is, my lord, I'm relying this 2 judgment, my lord. So, and so far, my lord, the witness, my lord, even the detailed deposition evidence, my lord, annexed, my lord, PW 1 to 14, my lord, page 58 to 49, my lord. There's not a single witness, my lord, there's any adverse evidence against me, my lord, against the alleged accused person, my lord. And that other PW 15, 16, my lord, it must be on PCR, my lord. They are also, my lord, they are, since they are not directly connected, but only official witness, my lord. There's also, my lord. So therefore, in respectful submission, my lord, at this moment, my lord, in the factual circumstances of the case, my lord, since all the substantial evidence has been already recorded, my lord, there would no impediment for it would not be prejudice to the prosecution if the alleged accused person enlarged on bail, my lord. It's my respectful submission, my lord. Therefore, in this factual background, my lord, alleged accused person may be enlarged on bail matter, under any term and condition. This matter.
Your Lordships, yes, of course, earlier bail was granted and it was cancelled by this honorable court. And when it was already cancelled, now this become a subsequent bail applications before this court. And new ground has to be made out for the exercising of entertaining these bail applications. Your Lordship, here there is no any change of development and difference or new ground is here pleaded in my petition, petition. In your Lordships, 2004, bracket 4, Supreme 84, Supreme Court of India,
2000?
2004,
2004?
within bracket 4,
4?
Supreme 84.
Supreme 84?
Supreme, yes, Supreme 84. It is between Kalyan Chandra Sarkar appellant versus Rajesh Ranjan alias Papu Yadav and another respondents. Your Lordship, incarceration period is of no consideration while there is a heinous crime. And in this judgment, in para number 19, your Honorable Apex Court has observed, before concluding, we must note, though an accused has a right to make successive application for grant of bail, the court entertaining such subsequent bail application has a duty to consider the reason and grounds on which the earlier bail applications were rejected. In such cases, the court also has a duty to record what are the fresh grounds which pursued it to take a view different from the one taken in the earlier applications. In the impugned order, we do not see any such fresh ground recorded by the High Court while granting bail. It also failed to take into considerations that at least on the 4 occasions order refusing bail has been affirmed by this court, and subsequently when the High Court did grant bail, this court by its order dated such and such cancelled the said bail by a region order. Earlier order was cancelled order was a region order, Your Lordship, by this honorable court. And to overcome that region order, this applicant has to be make out some extraordinary region to overcome that region order. From the impugned order, we do not notice any indication of the fact that the High Court took note of the grounds which persuaded this court to cancel the bail. Such approach of the High Court, in our opinion, is violative of the principle at binding nature of judgment of Supreme Court, rendered by its list between the same parties, and in effect tends to ignore and thereby render ineffective the principle enunciated therein, which have a binding character. Once it has been cancelled, there is a binding effect. And now, incarceration period, where I'm placing before this court, is that in this case, accused already during trial, he was already under custody for more than 6 years. And that is an incarceration. Now he is only asking for period spending just 1 year and yes. So then, Your Lordship, going by the Going, going by the position recorded so far, we cannot decide the case at the bail stage. That is the part of the duty of the landed trial court. Rest other witnesses is also there. And it is almost going to be concluded also. And by this gap of time, lapse of time, lower court maybe examine some more witnesses also. When at the verge of conclusion of trial, bail once cancelled may not be revived again. That is my humble submission before this court. No new grounds, no any change of circumstances. But there is a contradiction whereby 164 and court depositions of the daughter and the sisters of the accused. 164 within bracket 5 CRPC was recorded after the arrest of the accused persons. And the position was recorded after releasing of the accused persons. And accused person is there were the 3 164 statements. And one judgment, one order is also there. It is not a part of record in the petition. That's why that's why I humbly pray this court that I have to peruse the record. But I have that order in my mobile. It is order dated 28/10/2024.
28?
28/10/2024. It is Nami Radhe, who is a son of the accused persons. Hereby it is noted that he has given a false statement and perjury was done against him. But he was not taken into custody. But one, you should not repeat this thing again. There is a likelihood of any tampering and hampering of evidences. My landed has submitted that he is a retired police personnel. There may be a close relationship with this, whether remaining witnesses are superior or junior. There may be some bonding, maybe also, but fact has to be come out. And
From the
at
list
this
of the
stage,
witnesses, we have seen that at the time of rejection of the bail order by the learned trial court below, 14 numbers of witnesses were been examined. After cancellation, at the time of cancellation, 3 were examined, and thereafter, numbers of witnesses have been examined. And at the time of rejection of the bail order, it was 14 numbers who have already been examined. And during this pendency of this case, 2 more examined. That means only 2 left as per the submission of Mr. Tagun. So now case maybe at this stage of, yet obviously it is a verge of.
it's a yes,
Yes.
conclusion. And here, very interestingly, the sister and daughter who has tendered their statement before magistrate after the arrest of accused persons, and they now reverted their statement when accused was released. That is quite contradictory things
But
is going
at
on.
present, there is no, most probably 2-3 witnesses which have been leaved. These are all official witnesses. So probability of tampering with the evidence of those, the other witnesses or independent witnesses may not be there. I don't know. Maybe there may be possibility, but otherwise, if you see, those witnesses have already been examined. And even if they suppose changes their version or they turn to be hostile and all, these are the matter to be considered at the time of trial or at the time of passing
Yes,
judgment.
yes, exactly.
That is there.
Uh,
Now,
yes.
as per you, the case is at the verge of the end of the trial. So, and almost maximum with almost it's 16, 17 numbers of witnesses have already been examined.
Yes,
So I
as per
there will
my
be,
learned
as far as well as there is no new
submissions.
ground being a subsequent bail application. That is your
Yes.
submission
And
always.
incarceration period is nothing to do with the bail.
Incarceration period of incarceration may not be the zone of
Yeah,
consideration.
so when there is a heinous offense, and my humble prayer before this court is to reject this bail application again. And I like to ask my this private respondent counsel to assist me if there is some points to be placed before this honorable court.
Well, my lord,
Only just extremely sorry, my lord. Just to reply whether there's a change of circumstances or not, my lord, situation or not, my lord, I just point out my para 10, 11, and 12 of my application, my lord. Para 10, 11, 12 of my application. I highlighted, my lord, where there's a substantial change of circumstances, my lord, for filing. I've given the reason, my lord. Page 11, 12, 13, para 10, 11, 12, my lord. I've highlighted, my lord. That's just informal.
In your petition.
Yes, in my petition, para 10, 11, 12, my lord. To reply the change of the allegation on that there's no change of circumstance. I just justify that there's a substantial change of circumstance for filing this application, my lord. That's my response.
My citation may be, your lordship may be kindly go thoroughly in para 13 also. It's about incarceration period.
Yes, yes. You're citing the judgment of this Kalanchandra Sarkar, na?
Yes.
Yes, yes.
That will this is squarely covered in this such kind of case.
may I please, my lord, in assisting the learned PP, my lord, the accused surrendered on 17/6/2025, as per your lordship's order. And the bail was rejected on 26/6/2025. The impugn order being challenged here on 26/2/2025 or 26/6/2025, the learned trial court, after hearing the arguments from both sides, came to a conclusion that this particular your lordship's order was on 3/6/2025. Your lordship's order. Now, while coming to the conclusion, in the last paragraph that my lord will find in page 54 of the bail application, I don't have the copy, but I'm just trying to arrange in different manner from the index. My lord, if that is page 54 of the impugn order being challenged here, my lord, paragraph 11 of the impugn order, my lord, if I humbly take your lordship to the particular paragraph, page 54, it says, hypothetically assuming that the ocular evidence PW 1 to 14, on that very day when this particular bail was rejected by the trial court, by the session court, PW 1 to 14 was examined. And so far, and if they say to be true as they stand by the rule of evidence, if your lordship have found, page 54, the proposition propounded by the president has thus not remained the same as on today. More particularly, the projected eyewitness have not been deposed the same fact on so and so. Official during investigation, it may be the prosecution yet to examine 9 witnesses on that day. Now, my learned friend has said another 3-4 witnesses is still left. Now, the situation existing on so and so remains almost similar as on today. Therefore, having regard to the judicial discipline in the matter, judicial propriety, this court declines to grant bail to the accused. That is what the learned trial court said. Now, in other sense, my lord, now, so far, 14 witnesses have been examined. it says about propriety, it says about managing the change of circumstances. Now, so for the changes of circumstances concerned, the remaining witnesses who had examined later does not much have bearing over the matter. Because so for PW 1 and 3, what my learned PP has said about the deposition of the sisters and especially the son, were directly implicating the accused in their 164, which they have confirmed and reaffirmed in their PW1 in their deposition that there's a compilation of the witnesses. So it says that Mr. Nani Chatung was the one who has killed Mr. Taso Grayu. That has come on record. Now, apart from that, now at this juncture, when it is in the fact end of the trial, that after this, they will go for 313. And this is a very heinous crime, where both the sisters have started that Nani Chatung has told to them that he has killed Taso Grayu, this all, which could not be even said during the cross-examination. And it was rather affirmed. It was rather affirmed. So at this juncture, whether this will be a fit case to grant bail, because the accusation, the gravity of the offense, and imprisonment, the sentence in the event of conviction, these are all to be taken into account. These particular things were not taken into account by the learned trial court. Therefore, your lordship was pleased to reject that on the ground of perversity. On the ground of perversity. Because all these grounds were not taken. Now, even at this fact end, only when 2-3 witnesses. So by another date, by 14, this set of evidence will be examined. These are the seizure witnesses. And seizure witness, from them, CCTV footage were seized. And they were the one who has given the 65B certificate. Now, C4 seizure witness and IO is left to be examined. In this case, whether at this, and if there is going to be a prolonged time, that whether if it is going to be examination of witness, it's going to take another 2 or 3 years, that's a different issue. It's only about a matter of 1 month or 2 months where the judgment will be pronounced. Even day before yesterday in Uma Khalid case in Delhi High Court, they were behind the verse since 2020, and it is at the stage of hearing of the framing of charge. Delhi High Court said, no, when the case is progressing, the accused in heinous crime are not entitled for bail. And if the case is not progressing, if that is in steady state, naturally, it affects the right of the accused under Article 21. Because there's no delay, even in the trial. So when in this, apart from heinous crime, the accused are released on bail only when there is a delay on trial on the part of the prosecution. If no fault is attributed to the accused, normally bails are granted as there is a delay. But in this particular case, it is progressing smoothly without any delay from the prosecution side, and it is in the fact end. Therefore, my humble submission is, that the bail has to be rejected because it's a matter of another 1 or 2 months. It's not a matter of 1 or 2 years. And every day the examinations are being done, the witnesses are appearing. And so for the assurance of tempering, or whether they may temper or they may not temper, it's a condition subsequent to it's a condition subsequent. It's only one apprehension. He may temper, he may not temper. That's a condition subsequent. Therefore, at this stage, when the case is progressing in the right direction, he's not entitled for that. And Milord, I was little handicapped because my learned friend, another friend is also sitting in the courtroom. So at least whether your lordship will permit me just to file a compilation of the decisions by tomorrow. By tomorrow. Early hour, I'll file it through my friend. Tomorrow it's some decision where when the case is in a smooth manner, when the trial is going on very smoothly, and when there's no delay on the part of the prosecution, bail has to be denied. Only on that point. And your lordship also knows about that. Even without giving, it goes even without saying, even without citation also.
Yes, Tagore. In that case, do you have to, otherwise he wants to submit some citation, compilation of some citation.
My lord, that part, my lord, citation.
I'll hand it over to my friend also.
Let it silent to them, there's no issue, my lord.
Because I would like to give,
Okay, then
No,
will
my lord, my
the
humble,
order may not be passed. Let it be. I think it will be Monday.
my lord, I would like to submit the decision because Umar Khalid was only day before yesterday, that decision was, the Delhi High Court has given that decision in
Just-
Umar Khalid case. Delhi High Court has given the decision day before. My lord,
Okay, then you can submit this this
Well,
citation if you want.
why
and
I'm
we'll
praying-
be delivering the order on Monday. We'll fix
because
it for delivery of order on Monday.
because Umar Khalid was just delivered day before yesterday. So there are certain references. So I would like to bring it to your lordship's notice. I'm just trying to get that particular order from Delhi High Court.
Heard Mr. T. Tagore, the learned counsel for the petitioner, and also heard Mr. T. Tagore, the learned petitioner PP appearing on behalf of Judge, and also heard Mr. M.G. Singh,
MG Singh.
the learned legal counsel appearing for the listed matter on Monday for delivery of. Oh, Monday means
Obliged,
8, 9 for delivery. Okay,
Obviously.
by tomorrow you just submit it.
My lord,
and-
my lord.
Election.
But in this case, I'm appearing for the respondent.
Yes.
Return candidate. And on the last occasion, your lordship was pleased to dispose of one particular IA where we changed the maintainability.
Yes.
To one. So now, my lord, there are two
Sir,
more.
this is IA, na? We're
IA.
going to hear the IA now.
Yes, my lord.
IA.
IA, my lord, 65.
214.
65 of
65,
25.
lordship.
65.
Yes.
Okay, 65.
Here, my lord, we have prayed for actually, my lord, dismissal of the election petition under section, this application file under section 86. Basically, my lord, on the ground that the signature of the petitioner appearing on the election petition on each page of the election petition are not that of the petitioner. This is our allegation. And they have filed a reply. And along with this IA, my lord, we have filed another IA, which is numbered as IA 69 of 2024. And there our prayer is that if your lordship is satisfied that the application IA 65 of 25 requires consideration, then as is normally done, my lord, for sending it to the
handwriting expert, just to be said. So I'll pray that this IS 65 of 2025 may be fixed for hearing on a particular date, because other side,
So they have already filed a written
they
objection or?
have filed. Your Lordship wants to
Yes,
hear?
Lordship. In fact, Lordship, if Lordship allows, Lordship, today it was fixed for hearing of IS 65, Lordship. On the last occasion,
I-65 was fixed for, in fact.
yes,
Are you-
yes.
are
In fact,
going to
I
submit a-
prayed for,
It can be
I
taken up
prayed for hearing of both the IAs, but since learned, senior counsel had said that it may take some time to hear both the IAs. So, in fact, today it was fixed
No,
for
no,
IS
the
65.
question is
hearing
that
on-
in I-65, there was a prayer, I mean, the main contention of the application is that the signature, but the available in the election petition are not the signature of.
Yes.
And if it
Yes,
is
Lordship.
suppose this matter is heard, then only the case of I-69 will come, then whether it has to be sent
Yes.
for this examination to FSL or whatever. That
Yes.
will be this. So 65, if you want to submit, we can hear the 65. Or I
Yes.
don't know, Mr.
My
Mujumdar, are you not?
My submission will be, my Lord, both IS 65 and IS 69 should be heard together. Your Lordship will have to consider whether the allegations which we have made in IS 65 are to be considered.
65 suppose considers that
Yes,
69 will be definitely considered.
automatically the order will pass in 69.
Automatically order will be
Yes.
passed. So yes, Mr. Pada, what do you want to submit in?
Lordship, since this application IS 65 has been filed by the return candidate, so this is basically it's related to the signature in the election petition and then the signature in Form 26, Lordship. So there they have raised that under this application IS 65, they have filed this application under Section 86 of RP Act, Lordship. So here they have raised that the signature which is there in the Form 26 affidavit in the nomination, Lordship, that does not match to the election petition,
the
the signature in
signature
the yes, Lordship. So, Lordship, before entering into pairwise reply and on merit, Lordship, Lordship, I would like to in fact I have raised that this IA itself is not maintainable, Lordship, on the ground that Lordship is aware that under Part 6 of the RP Act, Lordship, some of the sections, Lordship, some of the sections
Okay, then you are going to submit if Mujumdar, you are ready, Mujumdar? Then we can hear it. Okay.
In fact, if my friend appearing for the other side is saying that now it is his signature, if they are saying we are saying it's not his signature, they are saying it is his signature. Then let his signature be sent for opinion of the handwriting expert. Based on that, my lord, your lordship can always decide. If the handwriting expert says it is not his signature, matter ends. Because under Section 80, when the election petition is to file, naturally, there is no denying that election petition has to be signed by the petitioner himself. We are saying that it is not his signature. So let the petitioner be called, let your lordship fix a date, let the petitioner come, put his signature, which will be his admitted signature, and his admitted signature along with the election petition will be sent to the handwriting expert. He will give his opinion.
Lordship, in fact, we have to go by, Lordship is aware that under Section 86, subsection 7, the election petition has to be concluded within a period of 6 months, Lordship. In fact, Lordship will see that in my reply, Lordship, the election petitioner has affixes both the signature, Lordship. One, my contention is that the signature which is there in Form 26 affidavit, Lordship, that has been filed along with the nomination paper, those are short signature of the election petitioner, and as per in the election petition, the signature is the running signature of the election petitioner, Lordship, which has been signed in all the, including election petition, including the documents, and that was considered
by the stump reporter lordship while while presenting the election petition within limitation period. So before going to that lordship, I have raised issue, basically two issues. First is that since under part 6, as I have submitted lordship, there are those provisions under part 6, some of them are substantive and some of them are procedural. Now section 87 is procedural and section 86 is substantive is in nature lordship. In fact, section 86 is substantive provision power of the High Court as a trial court.
But this signature, short signature is permissible with the affidavit with the with nomination paper.
Exactly, my lord. This is my submission. My short submission is by filing their reply, they have admitted that signatures are different. Now they are trying to justify by saying that this is my short signature. And in one petition, if there are two different types of signature, that itself is a ground for sending these signatures to the handwriting expert. Because they are admitting that signature is different. Now they are saying it's my short signature. Now you are not supposed to put two different signatures in the same proceeding. You have put one type of signature in the Form 26 and another type of signature in the election petition. Same person. So they are admitting the fact that there are two different signatures. Now they are trying to justify by saying that this is my short signature. For the purpose of, that is why, for the purpose of ascertaining whether the signature put by the petitioner in the election petition are, in fact, we are saying that this is not his signature. So the signatures appearing on the election petition, whether this is the signature of the election petitioner himself or some other person, our allegation is this was signed by some other person. Because the number of signatures have to be put by, there are in the High Court rules and also in terms of section 81 subsection 3, my lord, for the respondents of the copies will have to be served and true copy has to be served, meaning thereby that signature should appear in the first is in the original copy of the election petition to be filed, then extra copy for the court, second, and the third is for the respondent, and fourth is for respondent number 2. So there are 4 election petitions where the petitioner has to sign. So that is why, we are saying that he has not signed, and he is admitting that in some places my short signatures are appearing. That itself is a ground for sending it for opinion of the fingerprint handwriting expert.
Lordship, in that case, Lordship, may I take Lordship to page 151 of the election petition, Lordship. Now, since if that is the contention raised by the return candidate, Lordship, document number 7 is the Form 26, affidavit of the return candidate. Here also, it is clearly seen that the signature of the return candidate, he has given his short signature. And in the reply to election petition,
this is not the ground on which they will justify.
Different, Lordship, I'm just taking as a reference, Lordship, since reference on the ground that short signature is permissible in the Form 26 affidavit. So if I am the maker of the signature, if I'm not denying, if I'm saying that these are my signature, so it has nothing to, do with the return candidate. And in fact, it is a frivolous application, Lordship, just to delay the election petition, Lordship. And in fact, Lordship, with regards to what the return candidate has submitted, that with regards to providing extra copy and all, that aspect has been dealt with by this honorable court in IA 215, Lordship, which was dismissed by order dated, Lordship, it was dismissed by order dated 13/6.
I made this submission in a different context.
SLP was prepared against that order, Lordship.
My lord, I am not saying that true copy was not, sir. I am not on that. My learned friend is probably confusing. What I am saying is,
dismissed
no.
Honorable Apex Court, by order dated 29/8/2025, Lordship.
That is, my lord, IA which was dismissed was on a different footing. I have said that true copy, for the purpose of serving true copy on the respondents, there are 2 respondents in this case. Then he has to sign 4 copies of the election petition. I am not raising any question about the earlier IA which has been disposed of. What I am saying is 4 copies of the election petitions will have to be signed by the election petitioner himself. 1 for the court, 1 the extra copy for the court, and the 2 for the respondents. So since there are 4 different election petitions to be signed by the petitioner, maybe he has not signed. He has taken the help of some other person. That is why 2 different signatures are appearing. My learned friend has filed his reply at page 13, paragraph B, they are saying that with regard to the statements made in paragraph 6 of the interlocutory application, the deponent states that the signature appearing in the relevant Form 26 affidavit and in nomination paper both annexed to the election petition are short signature of the deponent, and the signature appearing in the body of the election petition and annexures are also the signature. So short signatures appearing in the Form 26 and also the affidavit, nomination paper and Form 26 affidavit, and long signature according to them is appearing in the election petition. I say, well, even the long signatures appearing in the election petition are not that of the election petitioner. That is why there is a necessity of ascertaining whether these signatures are his signatures or not. If they are so sanguine about it, my lord, if they are so confident about it, why they are objecting to our prayer for sending it to the handwriting expert? This will cut short the, my lord, the proceeding. Let the petitioner appear before the Honorable Court and give his admitted signature, and along with the election petition, the whole thing may be sent to the handwriting expert to ascertain whether these two signatures are of the same person or not. That is the simple issue, my lord. If they are objecting, that will itself show that these signatures are not his signatures. My lord, may I kindly take up paragraph 8 of my application? I'll just point out one thing, my lord. Why I am saying that it is not his signature. Paragraph 8 of my IS 65. That the applicant states that earlier the election petitioner was associated with the election petitioner for a long period of time. In fact, when it should be election petitioner and respondent, the applicant personally knows the manner and style of signature and handwriting of the election petitioner. Therefore, the applicant is confidently asserting that the signature appearing on the body of the election petition and the documents are not the signature of the election petitioner, and someone else has signed the election petition and the various documents annexed to it. This is the specific allegation of the applicant. So there is a necessity of ascertaining whether it is his signature, because in terms of section 80, my lord, it is the and in all other petitions, my lord, it is the petitioner who has to sign the application or the plaint. And why? What is the difficulty in getting the opinion of the handwriting expert if they are so sanguine about it? If they are objecting, that means they have got a doubt. By sending this matter to the handwriting expert, we, your lordship, can go ahead with other IA and for the early conclusion of the trial, because section 87 says it has to be completed within 6 months.
That is what I am into, lordship. Since if your lordship see my election petition, lordship, page 77 is the affidavit, lordship, which has that has been enclosed along with the election petition. So in fact, this affidavit also, lordship, that has been this has been sworn in before the Oath Commissioner, lordship, in the High Court itself. So there is no question of somebody affixing the signature of the election petitioner, lordship. Now, if we go by the para 8, lordship, of the return candidate, lordship, so that has been categorically denied, lordship. Since I am the maker of the signature, if I am saying that this is my signature, it has nothing to do with the return candidate. In fact, as I have submitted earlier, it is a fervent attempt to delay the election petition, lordship. And only after the affidavit will be considered, the election petition has been considered by the Oath Commissioner, lordship. Only after the election petitioner has put his signature before the concerned officer, lordship. So in fact, it will unnecessarily delay the election petition, lordship. And as for non-compliance, that has been considered whether the election petitioner has complied or not by this honorable court in 215, Lordship, IA 215. And against that, they have preferred an appeal, SLP against before the Honorable Apex Court. Honorable Apex Court was pleased to dismiss the said SLP in limine, considering that election petition has to be tried expeditiously, although that is not reflected in the order. However, it was dismissed in limine, Lordship.
This was
So,
not a
in
subject
fact,
matter of
the-
that IA. My learned friend is making a submission that this was also the subject matter of the earlier IA. Earlier IA was on a different footing, on a different ground. This plea was not taken in the earlier IA, which was discussed by your Lordship earlier. There the issue were twofold, my lord. One, that along with the election petition, the adequate extra copies to be served, as many copies as there are respondents, as required under section 81, subsection 3 of the RP Act, were not filed, number one. And number two, the election petition was not presented in person as is required by section 8. These were the two grounds. This plea, my learned friend is saying, was earlier considered and rejected. No, this plea was not taken, my. It's a different IA, different ground. So it cannot be said that earlier IA was dismissed, so this IA cannot be taken up for consideration. My views, my submission is very simple, madam. If this is sent to the handwriting expert, in the meantime, the Lordship can go ahead with the election petition with other proceedings, and this will expedite the disposal instead of waiting for this. So if handwriting expert will give its opinion whether the signatures are of the same person or not. And when I'm specifically asserting that earlier both the persons, election petitioner and the respondent, were associated, and I am aware, my client is aware of the nature, how this person puts his signature. And this is why he's saying, my lord, that these signatures are not that of the election petitioner himself. Some other person has put the signature on his behalf, which will not be in conformity with the requirement of section 81 of the Act. That is why my humble prayer is this, the petitioner may be directed to be present on a date to be suggested by my announcement, on which date he will come and give his admitted signature, and along with his admitted signature, and in terms of order 26 rule 910A, the election petition is sent to the handwriting expert for giving his opinion. Thereafter, the argument will take place.
Lordship, my humble submission is, if para 8, if it can be considered as gospel truth, saying that I'm aware of the activities and I'm acquainted with his signature and all, if that can be considered as gospel truth, then when the maker of the signature is saying that this particular signature is mine, then where is the question of Lordship sending it to FSL, Lordship? As I have already submitted, Lordship, in fact, this is a fervent attempt to delay the election petition, Lordship. Otherwise, only after being satisfied of the compliance of the various provision of the RP Act, the concerned registry has accepted it, and in fact, this it is not the case that this particular affidavit was sworn in before some notary or somewhere else. It was placed before the Oath Commissioner of the Honorable High Court itself. So there is no question of this signature being made by someone else, Lordship. So in my humble prayer is this IA should be, in fact, it should be dismissed with cause, Lordship. And in fact, with earlier, as I was submitting, Section 86, since it is relates to substantive power of this honorable court to dismiss the election petition for non-compliance of certain provision, Lordship. So since this itself is, Lordship is aware that this is itself is a substantive law, to invoke this substantive law, there has to be appropriate application filed under procedural provisions of the relevant law, Lordship. So that aspect also I have raised, Lordship, in my written objection. And secondly, it has to be accompanied with verification, Lordship. That also aspect should also be considered by this honorable court, Lordship. And regarding this signature, that it was signed before the Oath Commissioner, and that has been all due compliance was done. Only after that it was placed before the Honorable Chief Justice, and later it was placed before this honorable court, Lordship. So it has been duly
this-
compliant.
My lord, if this stamp reporter's report is to be accepted as a gospel truth, my lord, then there will be no election petition. In every case, after the stamp reporter passes it, then there will be no election petition, even if there is non-compliance of section 80, section 80, section 81, subsection 3. There are petitions filed because stamp reporter gives a report. Despite that, my lord, election petitions are being filed and your lordships are deciding without accepting his report to be absolutely correct. And here is the case, my lord. Your lordship is aware, your lordship is already directed an inquiry because earlier there was a different type of report. After the filing of the earlier IA, my lord, one more sentence was added that there was compliance of the High Court. Your lordship is aware of that, your lordship is directed an inquiry. Your lordship's order itself affirms that the stamp reporter report was manipulated subsequently. And that is why your lordship is directed. So that cannot be a ground for rejecting my application. Apart from that, your lordship will kindly see one more thing, my lord. In para 8, which I have just now read, my lord, I have said that we were associated earlier together and I am aware of his signature. In reply to this, my lord, the election petitioner has at page 14 of his reply has said that interlocutory application being based on personal knowledge of the applicant are wholly concocted, vexatious, frivolous, untenable in law and on facts. Hence, the deponent category denies the same and reiterate and reaffirm the statements made herein above. In my capital D. And your lordship is aware of the provisions of Civil Procedure Code, where, my lord, Order 8, Rule 6 says, Order 8, Rule 6, my lord, evasive denial. Where a defendant denies an allegation of fact in the plea, he must not do so evasively, but answer the point of substance. Thus, if it is alleged that they've received money, so the example has been given. So what Order 8, Rule 4 requires is, my lord, evasive denial will not do. You have to answer the point. Now, I have specifically asserted that we were working together earlier, associated together, and I am aware of a signature. Simply denying that no, it's not correct is not enough. Order 8, Rule 6 says that you have to answer the point. You must say whether you have worked together or not. You must say whether I am aware of his signature or not. He should have said that no, we have never worked together. That is not denying. So it's an evasive denial. You have not said in reply to this paragraph that, see, we never worked together as you are claiming, nor are you aware of my signature. That also you are not saying. You are making an evasive denial. That denial will not do in terms of Order 8, Rule 4, my lord. So that being the position, my lord, and the subsequent manipulation of the stamp reporter's report, I will pray that your lordship will kindly direct the election petitioner to be present on the next date to be fixed, and on that day he will come and put his signature, which will be his admitted signature, and along with his admitted signature, the election petition should be sent for the opinion of the fingerprint expert. Then your lordship will decide.
Yes, Mr. Tata, can you anything comment?
Lordship, with regards to reply to para 8, Lordship, here it has been specifically said that it is based on the personal knowledge of the applicant. So it is that part we have
personal
denied.
knowledge.
Yes, and then Lordship,
He is claiming that he is acquainted with the signature of the election petitioner.
And we were associated together.
Lordship, it is and subsequent is it is wholly concocted, Lordship. I mean, there is a denial. I mean, it has been categorically denied that it is concocted, Lordship. So although he may have been, say for instance, he may have been acquainted with the return candidate, Lordship, but however, it cannot be said that he is aware of everything, Lordship. And another aspect, Lordship, is just I have submitted earlier also, Section 80 with regards to it has to be filed within appropriate provision under the Civil Procedure Code, Lordship. Lordship may kindly para 11, Lordship, of my reply, Lordship. Here I have specifically pleaded, Lordship.
Para 11 of?
11 of reply, Lordship.
Para 11.
Sorry, page 11, Lordship.
Yes.
Page 11. Para 3. Lordship, Mary Lordship, that under Section 87 of the RP Act, it is specifically provided that the procedure for trial of election petition should be as per the Code of Civil Procedure. Part 6 of the RP Act, commencing from Section 79 to 122, deals with dispute regarding election petition. Few of the sections mentioned in Part 6 are procedural in nature, and few other sections are substantive in nature. As per the instance, Section 80, 80A, 81, 82, and 87 are few of the procedural sections, whereas few other sections, Section 86, 98, 99 are substantive in nature. In the instant case, Lordship, the aforesaid application has been filed under Section 86, read with Section 81 of RP Act. Section 86 provides the substantive power to the High Court as a trial court of the election petition to dismiss an election petition for violation of Section 81, 82, and 117 of the RP Act, Lordship. These substantive powers of the High Court under Section 86 can be raised only through appropriate application filed under the Code of Civil Procedure, Lordship. So there is no appropriate application before this Honorable Court under the appropriate provision, Lordship. That aspect may also be considered, Lordship. And secondly,
My reply in this regard will be Section 86, you Lordship will kindly see, is absolutely clear. Section 86 says Lordship has got 86. 86 says when a High Court shall dismiss an election petition which does not comply with the provisions of Section 81, 82, and 117. We have filed the application under Section 86, this provision, because this says that this will be dismissed. So you have power to dismiss it under Section 86. So we have filed the application under 86. CPC doesn't provide for any provision so far as non-compliance of Section 81 is concerned. For non-compliance of Section 81, application is to be under 86. We have filed under 86. And non-compliance, we are saying of Section 81 because Section 81 provides that presentation of election petition by the petitioner himself. And we are saying that he has not signed the petition. So the presentation was not by him. That is the case. Lordship will pass the appropriate order, my lord.
Yes.
in the meantime, Lordship.
65. I see 65 2025. Heard Mr. D. Mujumdar, the learned senior, assisted by Mr.
Yes, this was.
As Biswas. For the petition of the return candidate, and also heard Mr. A. Tata, the learned counsel for the respondent of the election. Order is a try to pass the order within next week.
Yes.
Lordship, in the meantime, Lordship, a fixed date may be given for hearing of IA 214, Lordship. Since this matter has already been delayed, Lordship.
After the disposal
Because of so many IAs that has been filed by the return candidate, Lordship.
Let this be disposed of.
IA 214 is for what? IA
For,
214?
For rejection of plaint and
No, madam. It's
for
order
striking out,
16
Lordship, of
for
certain.
striking out certain paragraphs, madam, where no cause of action is there according to us.
So it's
that
a
can be taken
different,
up after this, my lord, because
no,
the lordship, if your lordship
it
allows
is
our
on different footing, Lordship.
petition, if your
So the
lordship
fixed date
allows,
can
if your
be
lordship
given.
dismisses our petition, it is all right. But if your lordship allows our petition, then the election petition will have to be sent to the handwriting expert. So the no further.
Lordship, it is on different footing, Lordship. If that, if say, for example, if the order is passed in favor of the return candidate, then this election petition itself will go, Lordship, in 214, IA 214. They have paid, that has been filed under Order 7, Rule 11 and Order 6, Rule
For
16.
striking out some of the para.
Yeah, that's a different.
Striking out as well as rejection of of the election petition, dismissal of the election petition under Order 7, Rule 11.
No, madam,
But the
without
question
deciding
is,
this.
once maintainability issue has already been decided, again 214, why 214 is there?
214 is for striking out, my lord. After striking out, if your
Striking
lordship
out.
finds there is cause of action, then your lordship will not dismiss. After striking out certain paragraphs.
Maintainability issue has already been
No,
decided.
ma'am,
I think.
there is not maintainability. There is under Order 7, Rule 11.
Yes, you have prayed for striking of some of the
Yes.
city para, but the
My lord, our prayer is under
But then-
Order 6, Rule 16, read with Order 7, Rule 11. After, if your
So
lordship
here-
dismisses my petition, the petition goes. If your lordship allows my petition also, in that event, your lordship may say that, no, I'm striking out some of the paragraphs, but some of the paragraphs are there. So your lordship will not dismiss that election petition on that. Depends on the kind of order your lordship will pass.
but the case is already delayed, I think, Mr. Tata.
Lordship.
Already delayed, I think.
Yes, hearing of 214. And in the meantime, your lordship may please to pass the order.
And no difficulty, your
for,
lordship can fix a
IA
date.
65 lordship.
214 of ST matter. When need a convenient date for 214? Yes, Mr. Mujumdar, any convenient date, because most probably up to this my roster will be in the principal seat, I think so.
Fine.
Not sure.
Fine.
What will be the physical presence, it will be after Puja vacation only.
Right.
But prior Puja vacation, if anything, it shall be here from here only.
Yes.
So 214 developing election. In the meantime, I'll pass the order, and if
Yes.
this, suppose what
Yes.
kind of order it
Lordship.
will come. Yes,
Can it be on 24 lordship, 24 September?
Yes, ma'am.
If that
13
is
24,
convenient.
ma'am.
24 can be, but this last week will be, I think it will be a motion day.
Normally,
All day,
yes.
motion week will be declared,
So-
I think, that day.
18 then, 18 or 19 lordship.
18 or
19th is a
That is
Friday.
convenient for
19 can
Lanet
be,
Singh.
19.
19th.
19 can be.
19th.
বাকি
Alright.
that's okay, order point. A election petition 5 of 2024. IA 214.
I'm taking leave, madam.
Oh, sure. 214 2024. IA 19 2024. You could take it at 18 1990. You could have list him 99. Are I 65 or 69? I go to both I 65 and 60. Better or what? Because 69 will be same footing, it will be, so
Yes.
we will show
Lordship.
the hearing of both 65 and 69.
Yes.
Because 69,
Lordship.
if 65 is allowed, then 69 will
Allowed.
automatically come. So no need
Yes.
for hearing again for 69. If 65 allowed,
Lordship.
then 69 come. If it doesn't allow, then it will be, both the petitions will go.
Lordship.
Okay.
Lordship. Deeply obliged.
Madhav.
Yes, what is the item number 80?
May it be lost, my lord. This is a criminal appeal, my lord, against the judgment of non-existing judge.
This is the first day today.
My lord.
First day.
First,
This is the first day, na?
yes.
So we'll issue notice. Yes, you are appearing. Maybe it is a statutory appeal
Yes, my statutory appeal, my lord.
for against conviction.
There are 13 appellants, my lord. They are the
13.
victims of a cross case. In their case, one of their party was killed, my lord, and there was a separate session case in which this other side has been convicted. Again, this, of course, they are filing a appeal also because the sentence is very inadequate, very simple sentence, my lord. But in this case, my lord, which was filed by the other side after about 8 hours of the occurrence, and the judge also in the judgment itself.
That appeal is also pending before.
These appeals, two appeals are disposed of. Two appeals are, in this case, in the cross case, which they have filed as a counter blast to our case, my lord.
we are also convicted. There are 13 appellants, my lord. They are convicted for 3 months and fine of rupees 1,000. And in that case, my lord,
Your
one of
case
the,
was your case was a murder case.
yes, sir, one of our party men was murdered.
And in that case, all the accused persons were acquitted or
No,
convicted?
no, they are not acquitted. They are given only one of them was given 304 part 2, 8 years punishment and fine of rupees 10,000, and rest were given 3 months imprisonment and fine of rupees 1,000. In the cross case, which they filed after 8 hours of the occurrence, in the judgment itself it is reflected, my lord. Unfortunately, and they entered in our house premises. These all these men, and we are convicted for 3 months imprisonment and fine of rupees 1,000. So this appeal
So
magistrate
you are for 3 months
3 months,
and fine of rupees 1,000.
1,000.
So
We
you
are of course
convicted under which
on the
section?
bail.
You are
Of course,
convicted under which section?
convicted under section 323, 341 and 417, my lord. 147, 147.
3-1.
Operative part of the judgment is, my lord, at page 80. Page 80,
No,
we
you
can
were convicted under 147 and 325.
320, 323, my lord.
Oh, then your all title pages are here.
Yes.
You have to correct it, modify it.
Yes. My lord,
Your cost title is incorrect.
cost title, my lord.
Cost title is wrong. Your cost title is, so you have to modify or amend your cost title.
No, my lord, I have mentioned here.
I don't know. There is the cost title is there is a wrong in cost. That's why I'm asking that why it has been for 3 months.
347, 348, no, all the sections there that mentioned in the FIR I have mentioned, my lord. But in the operative part of the judgment is page 80, my lord.
No, judgment will be your cost title is not correct.
Cost title,
You are saying the appellants are convicted under section 147 and 325.
it should, my lord, I may be, it should be 323, my lord.
Yeah, that's what I'm saying. 323 should
320, yeah. I may be allowed to get it carried. Of course, my lord, in the IA petition for suspension of sentence, but they are all on a previous bail. In the judgment, it is reflected, which will continue for 6 months.
So I is for suspension of sentence.
Yes.
Don't have any. Hard Mr. Average Rajpur Delan of the applicant I would first hard the learned edition appearing on behalf of citizens. This is an application section 4 PNSS for suspension of sentence pending service sentence passed in improved judgment and order dated 25/7/2025 in sessions case number 06/2023, whereby the accused appellants everywhere you have in the same wrong. Again 325. In I also yes, some repeating the same 325. You correct all this. How can I pass the order? I thought that I'll pass the order, but
My lord, I will get it today itself, my lord, with your lordship
No,
permission.
not handwritten.
Capital error, my lord.
handwritten is not allowed. Handwritten is not allowed. No handwritten is allowed. I thought that I'll pass the order in IA, but I also same mistake as did. So going to, there are some mistakes in the cost title of both IA criminal 926 only 2025 as well as the IA as well as the criminal appeal 328 of the appellant of the applicant will make proper correction and corrected cost title of the cost title will be by list the matter immediately after the correction.
Next week, my lord,
Date cannot be fixed after your correction. After your correction, we will,
I'll do it by tomorrow, shall I let it come to the
whatever,
next-
after correction, it will be put up before.
All right.
List.
This is an appeal, my lord. Filed against the judgment and order dated 4/7/2025, my lord, where this appellant was convicted under section 304, part 2, and sentenced to RI for 6 years and a fine of rupees 5,000. The prosecution case is, my lord, this that he
We
had
are
a
not going to hear the IA today. You don't know requirement of any written heading, I think. 6 years conviction is there. If you want to submit anything, you can, or. cannot.
First,
We will
LCR
notice
will
the
be
issue.
called for, my lord.
But
At this stage, LCR will be called for.
LCRB should be. called.
because the prosecution case that he kicked in the abdomen, my lord. Only one kick, my lord. That is the.
So that's why 403, 304 part 2.
Now question is, according to the doctor, no proper treatment was given to him because he was an alcoholic. And there was a money issue was there, my lord. The incident took place right in the morning at 5:45 p.m. Then he went for walk. And that way he went to the hospital, no treatment was given. In the evening, my lord, he felt his situation became, there was a lot of pain, my lord, he suffered. Then he was taken to the hospital. Then he was referred to.
So when he kicked, it caused the hurt in the vital part of the.
No, it was in the intestine part.
Intestinal part.
But
So it was, I think, ruptured or.
Rupture was there, but subsequently,
Rupture
yeah,
was-
spoke. The doctor said had proper treatment given, he would have been immediately, but that was not given, my lord.
So that's why earlier it was registered under 302.
Yes, my lord.
Subsequently, that's why most probably that may be the reason why 30 part 2.
So yes, but other witnesses also stated, yes, there was, because some money issue was there, he was supposed to pay payment. And his conduct also, so not, he used to take alcohol, liver problem was also there, my lord. That's why he could not withstand the kick, most probably. Right? And all this considered that may not be a case of 304 part 2 at case of 326, because I didn't have the knowledge that my kick will cause such injury to likely to cause death, my lord.
Obviously, that is one of the matter to be considered.
Yes, because there's no external injury as such, my lord. Because he went to went for walking, he went to walk. He was a laborer, man, skilled laborer. Then again he was taken to a doctor. Then in the evening only he was felt that the situation become alarming, so that he was taken to the hospital, man.
Because of internal bleeding and almost.
Yes, so no treatment was given to him actually. So there's some lapses on the part.
Okay, then we are admitting your appeal and we calling for the case record, and on next day we'll hear this.
Yes.
Heard Mr. P. Kotopi. Then it's for the appeal and also heard Mr. Adar Post. This is an application. 415 BNSS against the judgment and order, challenging the judgment and order dated 4/7/2025 as by Planet Edition Session Judge FTC Sipsaki in Sessions case number 26 SS of 2019, convicting the accused appellant under section 304 part 2 IPC, and they have been sentenced to RI for 6 years along with a fine of ₹5,000 with default deputation. Appeal is admitted. Call for the TCR, registrable duty need is the matter according after. He is in custody, I think.
He is presently in custody.
So then we are listing it after 3 weeks.
3 weeks.
List up. In the meantime, we may, where from it has to come? Of Sipsagar.
Sipsagar.
I had to same order for you. Ekunai, that it will be, matter will be heard on receipt of the DCR. Heard Mr. Kotokia. Okay, after 3 weeks.
May I please, Your Lordship? Lordship, appeal against conviction. Appellant was convicted under section 354-506 and the Lordship 8 of POCSO. Sentenced him to undergo for a period of 5 years, Lordship, for the offense under section 8 of POCSO. And the Lordship under section 506, it is 6 months and fine with a default.
We have made party is Piyush Das, no?
Lordship.
Informant. Was he informant?
Lordship.
Informant, he was.
Lordship.
So we are issuing notice at this date. Part Mr. L.R. Mujumdar, the learned counsel for the applicant, and also part Mr. M.P. Guzman, the learned should be. Yes. 415 PNSS against the impugned judgment and order dated 17/7/2025. Passed by learned special judge Fox Achar Silchar in POCSO Federal Special Case number 203/2020, whereby the appellant was convicted under section 354/506 and read with section 8 of the and sentenced him undergo RI for a period of 6 years and also fine of rupees 1,000 for only each in default payment. For 6 months for which was which section?
It is for Lordship 506.
506.
Lordship, with the age of 34, I can see.
And for 5 years?
And 5 was for POCSO, section 8 of POCSO.
লিখতে উল্টা হয়েছে তার মানে 6 months conviction along with 1,000 we say 506/34 and 5 years conviction and to pay 20,000 for 8 of the box 8 years. Notice to date 1 number 2 close jurisdiction police station routed to the office of the registry and also call for the DCR. We'll see matter according after 4 weeks we'll do after 4 weeks. I also same order. I is also there. Yeah. Same order. Oh,
All right.
My lord.
Yes.
This appeal has been filed, my lord, against the order and judgment dated 17/6/2025, my lord, passed by the learned additional session judge cum POCSO, my lord, Kamrup Metro. And conviction for, my lord, under section 10 and 5 years, my lord, rigor as imprisonment. And fine of rupees 10,000. At page 47, my lord, the operative portion, my lord. Para 32.
It is also section 10 POCSO.
10.
POCSO is there.
POCSO is there.
I was acquitted under section 354, my lord.
Got that relief. And thereafter, they were meant to file an IA, but they didn't file an IA. They have filed an additional affidavit. So we got a copy of the additional affidavit, which is laden with false allegations and lots of
No, in
fabricated.
IA, you have filed your objection. In IA,
The IA that we had filed,
no, this IA is the connected IA you have filed by this IA, now present IA,
the present IA is 834.
834.
Yes, that
834 is filed by the
Us.
petitioner,
Res-
by you.
by us.
Respondent number 2.
Respondent number
There is a number to is it? এইটো কি উল্টা পুল্টা?
There is a bit of a muddle up.
I. Ah, 834. এইটো তেওঁলোকে fact কৰা বুলি কৈছে। In criminal revision petition, you are the respondent.
We are the respondent number 2.
But this 3834 was filed by you only.
Yes.
Yeah, that's so double. Falsely is actually named wrong is names are wrongly shown or reflected.
Yes.
That's why we are confused. That's why I'm just
Even
asking
my
whether-
names, my name is not correctly reflected and the previous council's names have been reflected though. I was going
No,
to.
your name is there,
Right at the.
in a criminal revision petition, you are the respondent, that is okay.
Yes.
But IA, you are the petitioner.
We are the petition.
You have filed, but that's why we are confused. That's why I was asking you. Anyway, now have you filed your objection here?
No, so I'll be submitting oral.
Oral submission, okay, then it will do.
Actually, Lordship, I'd like to submit. Actually, after filing of the IA, an order is passed. Earlier, when I filed when I preferred the criminal revision petition, there actually there's a interim order in my favor. Now, after filing of the IA, there is one order. That order is the IA that stated is 11/9/2024.
IA.
IA. The penultimate, that is the paragraph number 11. That is the effective part of the IA. Paragraph number 11. If Lordship is at that page, I can read out.
Yes.
Considering the submissions of learned counsel for the parties and in view of the beneficial legislation as enumerated in Domestic Violence Act and the law propounded by the Honorable Supreme Court in Pravatagi Supra, the interim protection is granted to the applicant by allowing her to stay in her shared household along with her child until further order. Till then, the order dated 11/12/2023 shall be kept in abeyance. The meaning of this I is earlier there is a stay order in the proceeding in the domestic violence proceedings, Lordship. Thereafter, with this order,
So that earlier stay order is
kept in
not-
abeyance. Kept in abeyance. It is not vacated. The I was to vacate the earlier interim order. So that is not vacated, but it is kept in abeyance.
Kept in abeyance is the same thing as setting aside almost. I mean, there seems to be a legal question here.
So
How do we read this or how do we interpret this?
it is
Now
kept,
see, one order is there,
Lordship.
that operation of order is kept in abeyance.
Right.
That means no stay is operating. Otherwise, it means
Broadly.
broadly.
Miss Lordship. But
Literally may not be, but broadly it seems.
whatever it may be, but this IA can be disposed of, and what is granted here, that is the bone of contention in the criminal revision petition, Lordship. What is what protection is interim protection is granted, that is the bone of contention.
That means she is that you are.
We have
providing
tried, we have got the relief. We have got the relief and we are residing there with many difficulties, of course, which we were trying to resolve amicably or through the protection officer. We didn't need to come to the court for all those small issues. Although these are substantial issues like running water, electricity and things like that.
So, Lordship,
However, we thought we will resolve it with the protection officer.
that's why I filed one affidavit on the last that it was fixed, not that day itself. Actually, I filed one affidavit. Why actually she cannot be allowed to stay in her shared household, explaining that. And that I did not file in the IA. I filed in the main case. So under that circumstances, my prayer would be to post the case for hearing, Lordship, and along with this IA, both the cases can be together and disposed of then.
But the IA can be disposed of because we have got the relief.
Is there any?
There is no substance whatsoever. There are new cause of action that as they're trying to bring in. A man 3 times her size is alleging that she assaulted him. That's unacceptable. So therefore, if it goes further, your lordship may just decide on the matter. But the whole thing actually needs to be resolved. Not need to
How
be
do you think that it may be sent before mediation? Is there any scope for? If that is there, then we are now in the
waited.
mediation drive. We are there. So
Yes, mediation drive is going on. We waited for several months to reunite the family, if possible. But at the end of several months, they have come up with these false allegations, false FIR, and false everything. So therefore, it is quite clear that they are not willing to negotiate in any way.
In last 7 months, 6-7 months, Lordship, there is no false FIR, there is no FIR at all.
It's
In
all
like
enclosed
7
in the it's all enclosed there, the additional affidavit.
Lordship, both the
but by this petition, you prayed for vacation of some interim order.
Interim order. And we got the relief and we are there. And now our simple prayer is that the domestic violence case, which as such is a summary procedure, should have been finished within months, could carry on and finish the issue. All the findings will be there. So the relief that we wanted and the appeal that they have come against is all resolved actually. And this matter needs to be disposed. That is our humble submission. Rest the lordship may decide.
my submission is that Lordship, matter may posted for hearing, Lordship. And along with this main application, criminal revision petition, the
Main application, what is your prayer? This is to file by them for seeking some, and that they have already submitted the relief. They have already gotten.
main
Maybe some,
application,
but otherwise they have got the relief. Now, what is the main case?
that is only interim because it is kept in abeyance. There is an interim relief only in the through the IA. When the previous interim order is kept in abeyance, that doesn't negate my prayers in the main criminal revision petition because it
So,
is
what
kept
is
in
your prayer
abeyance.
in the criminal revision petition? To that. So basically, there was an order of 10/6/2023.
Yes. So the impugned order is there. Against that impugned
That
order.
in the DV proceeding, that order was impugned order was there.
Lords.
So, as per your interim prayer, there was a prayer for the stay of this interim relief.
Lordship.
It was granted, but subsequently in the IA, the order was passed, whether relief was also granted or whatever. There may be a confusing otherwise anyway. So you are basically against the order of 10/6/2022. Okay, then we can hear the matter. Otherwise, as per is submitted by Ms. Sakia, that especially IA the matter, but if you insist that the
Lordship,
IA is not.
I actually pray and insist on that because that is not the
because it is
finality of.
kept in abeyance.
Yes.
Okay,
And-
then better
and
to
the
hear
next
and
day-
hear the matter, entire matter at this revision should be heard along with the IA, I think, in that case. If he is insisting that though there is relief is there and then everything is there, but still it was kept in abeyance. So
There is sufficient material why it should be, actually, it should be, the impugned order should be stayed or it should be altered. Why? There are lots of materials. Today I don't,
If she wanted.
today I don't want to come on the factual metrics because we have to, in any case, we have to go for a hearing, detailed hearing on this.
yes, what do you want to submit?
So I have only 2 or 3 small submissions. On this additional affidavit that they have placed before the court is subsequent to their petition and subsequent to the relief that we have received in the eye. So this matter would carry on in this fashion. They would just bring additional causes of actions every now and then, which may be real, may not be real. So many things coming in. So is that how we are going to go onto the hearing as well with all this confusion? Or shall we just actually dispose of the eye? We have got the relief. And if there is at all a hearing necessary, it can be only on the
There are some legal complications are there because in one hand, you're saying that you got the relief.
Yes.
It's okay. And as per the order of 11.9 or whatever, this order also speaks that you can be share household and everything, but the order of interim relief may be kept in abeyance. That may, otherwise, I don't know, may affect him also because he is against that order only of 2013. In that connection, if you see, there may be some complications with allowing or disposing the IA at present. So better, I think better to hear both the matters together, one point. And another one is that if suppose the additional affidavit is also there, we will be most probably concentrated our hearing basically on this order of
the impugned order.
Impugned order.
Yes.
That much.
Yeah.
There may be subsequent development, there may be many things,
There may
but
be.
let us concentrate on that
Yeah.
in interim order.
Yes, because we have filed a reply to the additional affidavit.
Yes.
Because we are trying to take up whatever they have filed, we are trying to take up with the different service providing agencies, to the different authorities that they have gone to. Because it again becomes a subject, another subject matter. So therefore, otherwise, if Lordship thinks, it can go for final hearing. If at all, both matters together can go for final.
Otherwise, also, Lordship, if respondent agrees for the mediation, we can try for the last time, we can try for the mediation also.
One aspect is there, you are, whatever, as per the order of that order, you are now, at present, you are getting the relief to some extent, minimum.
To some extent, we are getting
You're getting the relief. So in this case, if you think that it can be sent for mediation, we don't have any, because as a court, we are actually ready to go for that. So we are fixing a date for hearing. By that time, you just tell us whether your parties are also agreed.
Yeah, we have to
for
get
the-
an instruction.
You take the instruction.
We'll take the instruction.
Then we are listing both the matters for in hearing column, both the matters for it. Heard Mr. M.K. Das, the learned counsel.
Endeka, Lord.
Sorry?
Endeka, Dr. Endeka.
Oh, Eldeka. उल्टा पुल्टा बस नाम तो बोलो और टिकट तो एंड का है but and the learned counsel for the petitioner also heard MS Iseke, the learned counsel benefited respondent number 2 and heard Mr. R.R. Kaushik, the learned counsel for the learned additional people for the status. এই দুইটা একলাই করব আইএস ক্রিমিনাল আই আর ক্রিমিনাল রিজন পিটিশন একটা considering the submission made by the counsel for both sides that the matters be listed for hearing. Registry is accordingly directed to list the matter in the hearing column. After 2 weeks, we'll do after 2 weeks. And if you get the instructions in that regard, then definitely immediately we'll send it for mediation, or otherwise we can dispose it. Because matter is almost not so behind matter. Okay, then we are listing it after 2 weeks.
All right.
Just take instruction and report.
Much obliged.
Right?
26.
Lordship, in
filing this present appeal, there's been a delay of 115 days. So
How many days delay?
115 days. I has been filed for condemnation of delay. I 91125.
Delay is of okay then. Yes, Mr. Kaushik, here it is 115 days delay. 23, 24, 25 days delay, it's okay, but 115. What to do?
Well, here, otherwise, I have no objection, but the thing is that private respondent is also there. Madam.
Private respondent is also there.
Yes, ma'am, notice should go.
We'll do one thing. This is the first
Yes.
first day, so we'll issue notice. This time. Let us see. Otherwise, we may dispose of the matter. You are against the acquittal.
Yes, against the acquittal.
What was the case for?
Yes.
Case was registered under which section?
NI case.
Oh, this is NI.
NI case.
Then notice.
Oh, then to obviously
Notice of quit.
notice. Only one maybe. But we issue notice. We take steps on the respond number 2 to register AD and SBA process. With the matter
2 weeks.
after 2 days.
Public.
And then it did. So what is the delay about here?
May I please your lordship?
I
There is an application under section 149 of subsection 4 of BNSS 2020. It's a leave petition, your lordship. Seeking leave to refer and appeal, your lordship,
What is a night?
against the judgment and order dated 21.
Yeah. This 419 is corresponding to which section of CRPC? 372 or 378? He is victim or who is she? Victim?
So victim, your lordship. Complainant, your lordship. It's a leave petition, your lordship.
It was a complaint case.
It was a complaint case, your lordship.
Okay, NI.
NI case, your lordship. 130.
So by issuing notice here, it is against acquittal, na?
Yes, your
To
lordship.
issue notice here first. Notice to
It's
the
a leave
respondent.
application, your lordship.
Pardon? Leave application, but
Leave application.
for victim leave application is required. For victim also leave application is required. Victim. I don't think so. For victim, I don't think it is required.
Going for the judgment, I some kind.
What's it?
Actually,
Oh,
no,
Celestial.
CJ case has been given by the apex courts of Celestium Finance. So now there is no need of leave application, but as a statutory right, there is a 378(4). So I have filed this leave application.
But there is a judgment, madam, Celestial,
Celestium
but I
Finance.
have not gone through because, to be honest, when I don't have that much knowledge in NI case, I don't believe it. That's when perhaps something has been cleared.
Okay, then if you want to make submission in this petition, then you're not in a position to hear the petition now. Simple 2-3 orders will be passed. We are listing it on. So what do you want to say?
Your Lordship, same, to accept this leave petition, Your Lordship.
Hmm?
Accept the petition.
Accept?
Accept the application under section 140, 100, 419 of subsection 4, Your Lordship.
This is your lordship or the planet members, please.
Same nature of leave petition, Your Lordship, has been accepted by this honorable court.
My lord, in that judgment, my lord, in Celestian, my lord, if I am not wrong, my lord, complaint has been that the complainant is found as a my lord, victim, my lord. That's why, my lord, that leave is necessary.
That in that judgment, actually, there's the observation of the Supreme Court.
Yes.
Panel.
Yes, ma'am.
Your case is also 138 and
138.
your good name?
AM Siddiqui, Your Lordship.
Huh?
AM Siddiqui, Your Lordship.
কোন নম্বর রয়েছে কোন কেস রয়েছে একটু বেশি same prayer. Yeah, the application 494, same order, more or less, same. Okay, we are allowing your leave petition. And the criminal appeal will be numbered and registered by the registry person.
Much.
The 9 I ask order, please. Same order. It will take some time. Wait. It will be just an egg. Yeah. Last week. 20.
Yeah, it's not, this is my appeal against acquittal. So I is for under section 4194 leave to appeal. So under the
This is case is a complaint case?
complaint case,
An act or what?
not an act, my lord. Complaint under section 409, 166, 427, IPC under it.
Who are you?
I'm the complainant.
Any submission? Anything you want to submit?
My submission is that, my lord, while appreciating the evidences adduced by the complainant, PW 2 and 3 were not totally appreciated, my lord, and thereby
the findings is totally perverse. And the evidence of PW3 was so specific that there was offense under section 409 and 166. It was really ignored by the trial court. So there is every scope of conviction in this case.
So case was registered under 409-166-2427.
Yes, ma'am.
It's 166 or is the correct section 166?
166, 409, 166. Lordship will find in my leave petition, I've stated para. Also judgment is mentioned that regarding para 2 of my leave petition. 166.
Public servant, disobeying law, all these.
Yes.
409 was also there. Na?
409 is also there.
State of Assam is a formal party. State of Assam is formal party.
Formal party. Formal party. I have subcopy already.
Also had Mr. Arar Kaushik on behalf.
I will.
494 PNSS for repeatedly against Twitter against the implement judgment and order dated 25/6/2025 passed by Ranit CGM Shribhumi in CRDS number 620 of the is submitted by Mr. Sa that the Ranit trial court below has not first considered the evidence of PPW 3, 2 and 3 over the witnesses and also the independent witnesses of the case and without proper appreciation of evidence and arrived at a wrong decision, acquitting the respondents, acquitting the respondent from CRT number 620 of 70, which was registered 409 166 with 426. Being aggrieved by the order of imperial order in judgment dated 25/06 2025 as by land CG. The petition, the present applicant had already filed an appeal and hence this petition to enhance this petition being for specially filed and register the affidavit against. Considering the submission. The present the petition is and registered accordingly within it for registering, numbering and registering the affidavit. And thereafter, the matter will be listed.
Right.
Only. Other matters where they put. Other matters are left over. Huh?
Your Honor, item number 36, item number 37.
33.
36.
Ah.
The legal aid matter, your counsel.
Huh?
Legal aid matter, counsel. Legal aid counsel, and for already 1198 days has been delayed, your Honor. So matter may be fixed, your Honor.
And these are all leftover matter. One order is fixed, then every order has date has to be given. We don't have any.
Lordship will give a date.
Date.
No, all are leftover.
No.
Directly